Lordships, may I seek your indulgence in mentioning item number 4 from supplementary causes? I am appearing
Item 4 of which cause list?
supplementary.
Okay, yes. The hearing item. Yes, what about it?
Your Lordship, my senior is on, Emily L. Changte is on maternity leave, so if the matter...
Okay.
Respondent number 2, Miss Emily.
How long has she taken leave?
My Lord, till July 31st.
Okay, right. On the prayer for adjournment made on behalf of
Miss Emily L. Changte.
Mrs. Emily L. Changte, who is on maternity leave, lives the matter in the next month.
May I seek your Lordship indulgence in mentioning item number 16, part 2.
Single bench?
With the concern of...
Single bench matter?
Yes.
That is when the single bench sits.
For admission, item number 1.
Please, Your Lordship, in the last court date, this honorable court have called for the appearance of the CEPWD for assistance,
Okay.
reassuring that it's not a punitive measure but to assist the court, Your Lordship.
Regarding what?
For constructions of the airport, Lempi Airport.
Yeah, but especially what? Especially with regard to the what? Especially with regard to the conveyor belt or what?
Conveyor belt. My learned friend was taking this.
Yes.
So, my lord, there was a dispute. I mean, we had some sort of argument regarding the conveyor belts, my lord. So, according to us, my lord, as per the blueprint, there are supposed to be 4 conveyor belts. But as of today, there is one new conveyor belt and one old conveyor belt which has continued to be used before it was renovated, according to us. And then the 2 other conveyor belts which are supposed to be constructed has not been done till today. So, my lord, our claim was that the respondents, the contractors have claimed that they have finished 96% of the work. So, our argument, my lord, was that 96% is not possible. It's not possible that they could have constructed 96% as per the blueprint. So, now the court wants the assistance of these officers, my lord, to give a proper status of what's happening. And also the respondent number 5 and 6, my lord, the contractors, they have claimed that they are not working anymore, that they have handed over the work to the government. So because of this reason, it became even more necessary for them to give the status, my lord.
Yes, so the first question, are the contractors still working?
Yes, Your Lordship. Officially, there is no termination.
There is no termination.
Yes.
Then why are they saying that they are not working? Who is for the contractor?
JC Lanusang.
Where is he? Where is the contractor? He is supposed to be here. We cannot hear you. We cannot hear you.
Am I audible now?
Yes, you are audible.
My lord, that day also I make submission. Respondent number 5, he had a stroke. He was unable to come out of his house also. So that's why the work...
See, Mr. Counsel, is he doing the job alone? Doesn't he have any officers under him? Doesn't he have any employees under him?
My lord, yes, of course.
Then?
That's why the court directed to send the representative also.
Huh?
The representative.
Yes, so where is his representative?
It is in the court now.
Where is the contractor's representative? You are the representative. What are you? Huh? Site engineer. Do you know that this is a court? There is a certain decorum required to be maintained in the court. You don't come in a jeans jacket and a t-shirt. You go home and you change and then you come back. We'll be waiting for you. You go and wear a shirt, you come wear a coat. There's certain decorum. You go. Before you go and you come, we will take it up. What is this? What kind of client is this? Should maintain a certain decorum here. Yes, so first of all, is there going to be 4 conveyor belts? How many conveyor belts are supposed to be there?
Your Lordship, it's 4.
4 conveyor belts.
2 at first floor and 2 in the ground floor.
Ground floor is for
Arrival. It's
and the top floor is for
departure.
departure. And
Yes.
why do you need a conveyor belt for departure?
It's carousel, Your Lordship.
Okay, for that. Now, okay, there's another question. Is there any contract agreement signed between the contractor and the PWD for the airport?
Your Lordship, PW
Who
number
is
5.
the authority making the construction through the contractor? Which department is which department is the lead department or the department who has given the work order to the contractor?
PWD building, Your Lordship.
PWD building.
Yes.
Is there any contract agreement signed?
Yes, Your Lordship.
Where is the contract agreement?
It's in the we have already placed it before this honorable court, Your Lordship.
Now, as per the contract agreement, when is the contract to be completed?
Your Lordship, with regards to PW number 6, if I may take Your Lordship kind attention to the affidavit filed on 29/4/2026. This is filed by the state respondents, number 1 to 4.
Just answer the question. You see, there's no, we don't need to go through the pages. Just answer the question. Now, there are 2 contractors, correct?
Yes,
5 and 6 are the contractors.
yes, Your Lordship.
Now, the contract with the contractor, who is respondent number 5, when is he supposed to complete his work?
Defect liability is till 31st May
No,
2022.
defect liability is a different thing, Ms. Madam. When is the contract going to be completed? Defect liability is after the contract is completed,
In straight hands.
not prior to that.
Your Lordship, I just have to go through.
No, just tell your clients to come forward. Tell your clients to come forward. Don't shout across the room.
Completion date ka. Completion date ka.
The necessary part was completed in this 20.
And as per the agreement.
As per the agreement, one December,
Your Lordship, as per the agreement, it was supposed to be finalized by, completed by December 2024.
December 24, respondent number 5.
Yes,
And
respondent number 5.
it is not completed as on date.
As on date, it's not.
When is it to be completed?
not one.
Your Lordship,
Yes, Mr. Shanga, when is it supposed to be completed? When is the extension of time is given till what date?
No, sir, there are 2 components here. That is the necessary part, non-operational part, and the other is improvement operation facilities at Lempu. One is renovation of terminal building. That come under the state funding SASKI.
Okay.
Then the other one is the elevated road, the ramp outside that come under NESIT funding. So that NESIT funding was completed already in March 2025.
Okay.
The ongoing one is this
Under SASKI.
Yes, that's SASKI one.
This SASKI, when is it going to be completed?
No, earlier we had promised September this year.
Okay.
But there had been power problem, then change in scope.
So when will it be completed?
No, we expect it positively by December.
December.
This year.
And what about the respondent number 6?
Respondent, Your Lordship.
For both?
Yes.
For both, you are expecting it to be complete by December
Yes, sir. That
6th.
one, that NESIT part is already completed actually.
Basic part, okay.
Nasit party hai kambula kadro.
Yeah, that
Yes,
KR construction one.
With respect to respondent number 5, what is stated is that it's already completed because that one is a project under NESIT. Now, with respect to respondent number 6, it's ongoing and it is taken under the SASKI scheme.
Yes.
And the main problem that we are facing is the inadequate power supply. Now, the P&E department are taking care of it. There was a demand to the government for upgradation of the powerhouse. And expenditure sanction was already accorded. And now supplier for the same has already been selected. It's already finalized. Now the remaining is that we are waiting for the supply to be the items to be supplied, and then the work will resume as soon as the power supply as required is provided to the PWD department. Now that is the problem that we are facing now, Your Lordship. And once the we have the adequate power supply, then the security check-in area, which is now in the ground floor, will be shifted to the first floor. And the whole ground floor will be, as per the plan, it's designated for arrival. And then 2 conveyor belt will be installed. Now, one is installed. One is newly installed because in the northern side, as per the plan, it's designated. Now we cannot install it in the southern side because the southern side, as of now, as we know, is still used as a security. And in the first floor, it's 2 carousel will be there for the departure. Your Lordship, sir has still some input.
Yes, please tell us.
Yes, sir. Other than those power problems and the canopy, our main problem is that the main problem is now the power. Everything is ready on the first floor, departure side. We cannot move the ground floor arrival portion because the AC at the first floor will not be functioning because power supply is a little bit short. So if they can move to the first floor, we have still more work below at the ground floor. That is delaying us also.
So the first floor, if there is power, it is operational.
Yes, sir, it's all operational now because we cannot run the entire AC at one go. So P&E people are procuring some more transformer, which they have given the work or supply order maybe this week, I think. They said they'll be taking maybe 2-3 months. 3rd July. Yeah, they placed the order on 3rd July.
3rd July.
Yes.
When is it supposed to arrive? The
hopefully
transformers?
They are saying 90
tentative.
days, sir.
Huh?
They are saying 90 days.
90 days. 1st July, that means July, August, September.
And they are saying 6 months will be needed for the entire completion.
My God. That means you will not finish within December.
But that's what we are still expecting.
And tensile roofing.
Then that tensile roofing outside, that is also we expect to complete in 3 months. That will not delay us. Anyway, that was not delaying the function of the airport.
Your Lordship, with regards to the tensile roofing, what I would like to add is that as per the plan, there was a roofing made. However, that is not in the market anymore. So tensile roofing is newly made and deviation is approved as
So basically now the issue is power.
Yes, sir.
power.
That's the only thing.
And
So
none
you file an affidavit, ask the engineer in chief to file an affidavit, okay, the P&E engineer, he should file, giving an up-to-date status report with regard to the transformers that has been asked to be delivered
Yes.
for the airport.
My lord, may I make one submission, my lord? My lord, if your lordship will see, because I think one of the answers they have given is not completely accurate as per the blueprint. Because if your lordship will see the affidavit they had submitted, the state government had submitted, my lord. This was the affidavit dated 11 November 2022. There, my lord, they have enclosed the blueprint. And in the blueprint, my lord, this is at page 208. My lord, it is seen that the arrivals area will have two sections. Not one section, my lord, two sections. The arrival lounge 1 and arrival lounge 2. The arrival lounge 1, my lord, is supposed to be in the area which is presently used for the departure. Lounge 2 is the original arrival area. Now the first lounge is supposed to have 2 baggage claims, which means, my lord, 2 conveyor belts. And the old site is supposed to have 2 conveyor belts. My lord, we cannot stray away from this
Page
208, my lord.
Yes,
Because now
page
what
208 of the
affidavit dated 11
yes.
November.
Please look at that, madam.
Because it's written there, ground floor plan.
Yes, Mrs. Mary, please look at that.
Yes,
208.
Your Lordship, we're just,
And it's clearly written arrival lounge 1 and arrival lounge 2.
okay.
And this was made in 2020, my lord. This was not something that was recently created.
Okay.
Because if your lordship will see 206, the
Page
first,
2,
if your lordship will see the first page of this plan, page number 206, 204, sorry.
Handover, okay.
204 is the first page.
yes.
My lord, I'm not sure if that is the same.
No, I got this. Sorry, this is,
This is
it
a
says-
different one, my lord. There are 2 affidavits. One is the bigger affidavit dated 11 November 2022. Not this one also.
Oh, dang le, then it was dang le, affidavit are there.
On the same day, because last time, on the last occasion also, there was some confusion, my lord.
Give me this 204, page 204, this, not this. How many, what is this? It should be a running page, one running page. Why do you have 2 different running pages? Yes, sure. Yes, sure. Where is that? Show me that.
Joseph, he made the highlight. You refer, page kan okay lang.
That is different. That is the second floor. That's the first floor.
204 ne yaar. Chhade ko main file lang. Show me that.
My lord, it's an A3 paper.
Must be this only.
It's an A3 paper towards the end. Not this one also. I'm not sure. 11 November 2022.
It's so thick, I don't know, there's so many affidavits.
11 November 2022.
11 November 2022. Okay, okay.
Why aren't you giving this pagination? It should be a running page. The entire thing should be one running page. Again the same thing, compressive strength test for
It's
construction.
not this one, my lord. Last occasion also there was some confusion. There were 2 affidavits filed on the same day. One was an affidavit in opposition. The other was an.
Just, you see, just give it to him. Give it the entire thing.
11 November 2022, page 204. 204.
It starts from.
What is the page number there? There are 3 numbers. then you have to follow the court's pagination. We cannot follow your pagination. If there are 3 numbers, you make it 3 numbers in yours also.
No, the reason is, I think, my lord, I think some change was made in the registry, but in the original, which has been cut, my lord, it's shown 204.
You show,
Again,
you
refer.
show them their pages.
Yes, that one. My lord, 204. The
204.
cut, it's cut 204, my lord has seen the page number.
Okay.
On the bottom, your lordship must
You
will
see, is Mr. Counsel, you have to follow the court's pagination.
Yes.
Okay. So if there is a change in the court's pagination, you follow. We cannot come running after you.
Yes.
You need us more than we need you.
Correct. We will verify it, my lord. So now, my lord, your lordship will see towards in the bottom, revised redesign on 7th August 2020. This was made before the contract was awarded, my lord.
Huh?
This blueprint was made before the agreement was signed, because this was made on 7th August 2020 on the bottom. And on this same document, my lord, your lordship will see in the page, in mine it is at page number 208.
Just a minute. This is design on 1st October 17, revised design on 17th of August 2020. 208.
Yes, my lord.
Yeah.
Concept stage.
Yes.
Now 208, my lord will see there are 2 arrival lounge 1 and arrival lounge 2. My lord has seen it in the middle, my lords.
Arrival lounge 1, arrival lounge 2.
Both
Yes.
sides, my lord, have 2 baggage claims each.
Yes, baggage claim.
And it's also shown, my lord, on the side in the project sheet, it's shown ground floor.
Show them the page. Show them the page.
Your Lordship, we are into the page, but
Same page, no?
instead of wasting Your Lordship time, Your Lordship, this, what my learned friend has referred is first design, that is at the concept stage. At the concept stage, that was designed on 2020. Now the design that is used for the construction is we have already annexed, it's 2022. I think the booklet is also there. Because we have already submitted to this honorable court. And Your Lordship, in this new blueprint, there's only 2 in the ground floor, and I think the senior engineer would be able
So
to.
why? Okay. So basically, they've explained it. So from 4 it has come down to 2. But you see, whenever you look at a building or any infrastructure that is going to be built, you should do it with an eye to the future. As to whether there's going to be, are you expecting, don't you expect more traffic, air traffic in the near future? Do you think that the population is going to grow less in the state? Don't you think that more people will come into the state?
The conveyor belt at arrival, 2 numbers, was sanctioned on 23rd July 2026.
Okay.
2 numbers ground floor. So the departure which was installed and already handed over to the GRE department, it was completed and already handed over. The inclined conveyor belt at departure. So the only remaining is that another 2 at ground floor, which has been recently sanctioned. due to
Oh no, that's all
public
right. That's all right. We are not saying that it should be this or that. But you should have thought of the future, no? When we built this high court, when the PWD built this high court and the high court had given its inputs, we have made 6 courtrooms here. We are using only 3 right now, actually. But we are thinking of the future. So you're in that. So for the airport there, why are you only being satisfied with 2 conveyor belts? Why not 4? That's the query we are putting to you.
My lord,
Your Lordship, it was it was only proposed 2 numbers at ground floor and 2 numbers at first floor.
My lord, that is
Anyway,
not
that's for the future. That is, so it's explained.
no,
from photo
that
to-
is not accurate, because even in the affidavit they had submitted, my lord, that new plan, supposed new plan. I'm sorry to say this, I'm saying only out of sincerity for the state, my lord.
Yes.
I can see that there are still 4 plans, four conveyor belts.
Let us see that. Let us see that thing.
I think they will have to explain because we are not an expert.
No. Let us see that booklet
This
you
one,
were
it's
saying.
there.
Let us see that booklet. You say that there are only 2 conveyor belts. I hope this is not a case of a missing floor.
No, because I have just checked it from them now. Yes, lordship, let's hope it's not.
Can't explain, sir.
บ้านกำลังมอบส่วนกำลังปนิจุนโซต่างนิจู
Hey, Anshat.
Unless that is a third one, but that I have not seen. I have seen the second one, my lord, and this is probably another third one. I'm not sure if.
Anshat thiam lo la chu ta hang pali ya oma lo ma ya.
Baggage claim, baggage claim.
อันนี้ชุดรวมมันคือหรอโอ้ก็เสร็จแล้วเสร็จ
Let yes.
Your Lordship, this which appear 4 numbers at ground floor, the existing they have shown. The existing they have shown. This new one, this is the new one. This one left side and this right side, northern and southern side.
Please see. We are too far
Yes.
away to see properly.
No, lordship, what they are saying, this I understand. We are saying the same thing, my lord. Ultimately, once it's completed, this is what I'm trying to say. Ultimately, once it's completed, there will be 4 conveyor belts.
Okay.
And what I think what the officer is saying is, my lord, the old one will remain, and then they will construct 2 additional new. If
There is no space. There is no space.
he's saying there's no space.
My lord,
My
there
lord,
is no space.
what
for
about
4 numbers at ground floor?
because the blueprint has 4 numbers.
drawing an existing
They have just shown the existing drawing in the drawing.
When you made the agreement with the contractor, was it for 4 conveyor belts?
No,
or 2
only
conveyor
2.
belts?
Only 2.
Only 2.
Your Lordship.
Can you show us the clause in the agreement specifying that it's going to be only 2 conveyor belts?
See,
Agreement in the
agreement sukeng lobo mo.
Your Lordship, in the last court day, my learned friend Jessica Nusang, I have shown this honorable court. I think you will be able to show that clause in the agreement.
No, my lord, what I have shown is that the order only, that it is outside our work. It is nowhere mentioned in our work that conveyor belt should be included. That is my submission.
So you are not constructing the conveyor belt.
Yes, it is beyond the scope of the agreement between us.
My lord, that is also not accurate. I'm sorry to say this, but page 15 of the same affidavit, my lord, the scope of work given to conduct them is reflected. My lord, there it is shown baggage makeup area. Now when it says baggage makeup area, my lord, they are not going to say this is one baggage makeup area, this is another baggage makeup area. The entire floor is a baggage makeup area.
No, everything will be reflected, should be reflected in the agreement.
Yes.
Let us see the agreement.
Your Lordship, this existing 2 will be dismantled if the new one is completed. So, as per the plan 2 and as per sanction, there will be no 4 conveyor belt at ground floor.
There will be only 2
Only 2.
and two on top.
Yeah, or 2 on top, 2 on bottom.
And is there any mention of the number of conveyor belts to be made in your contract agreement signed with the contractors? Or have you left that portion blank?
Only 2 conveyor belts.
Is it reflected in your contract agreement?
Yeah, it will be there in the BOQ, sir. My lord.
So can you bring that BOQ?
We don't bring this time.
We'll bring it day after tomorrow. We'll sit. We'll bring it day after tomorrow.
Okay.
Let's be sure of that. You see, that aspect. That's all. And then we will see. I want to see, we want to see the exact number that you have, that you are going to construct,
Okay.
or going to make.
Two on top incline one has been already handed over. Has
Maybe,
been already completed.
maybe. So we'll take it up day after tomorrow.
Okay. Tomorrow. Okay, can so on.
Just bring the BOQ, show us the
Okay.
number, that's all. Right. Heard Mr. Joseph L. Rensley, learned counsel for the petitioner. Also heard Mrs. Mary L. Kiangpe, learned GA. The officers of the PWD are also present in person to help explain the work done by the contractors. Pusta. The engineer-in-chief PWD submitted that though the contract work being executed in the Lengpui Airport by the respondents number 5 and 6 were to be completed in December 24 due to various extension of time given to them. Which was till September 2026. It is now being considered that the contract work will be completed only in December 2026. However, full stop, not say however, say one of the reasons for the delay in completion of the contract work is the inadequate power supply being provided by the P&E department. Full stop. He however submits that the P&E department have issued supply orders for transformers to feed the power requirements of the Lengpui Airport. The supply orders were apparently made on 1st of July.
1st of July 2026.
On 1/7/2026, and as and when adequate power is provided, the contract work would be speeded up. Full stop. The PWD officials were also requested to ascertain the number of conveyor belts to be put up in the airport and to clarify by way of their contract agreement, BOQ, etc., as to the number of conveyor belts to be placed in the Lengpui Airport. Full stop. We also are of the view that is the P&E department a party here?
No, Your Lordship.
We are also of the view that as the issue of power supply is an important aspect for completing the contract work, the Secretary to the Government of Mizoram, P&E Department, and the Engineer-in-Chief, P&E Department, Government of Mizoram, should be implemented as respondents number
7 and 8.
7 and 8. Full stop. They are accordingly implemented as respondents number 7 and 8. A registry to make necessary correction to the cost title. Ms. Mary L. Kiangte will accordingly is accordingly directed to inform the secretary or PNE is enough, ENC is enough.
ENC is enough, I think.
Will accordingly ensure that an affidavit is filed by the engineer-in-chief, PNE department, with regard to the transformers that are being purchased for feeding power to the Lengpui airport. Full stop.
Your Lordship, with due respect, I do not know whether they have purchased a new transformer or not. It's an upgradation
Because he has said it. They are not going to ask for old transformers. They will clarify in their affidavit.
Okay.
Let them clarify in their affidavit. The engineer-in-chief PNE will clarify in his affidavit as to the adequate power to be required in the new airport, and the manner in which the PNE department are going to ensure that the same is provided to this airport. The said affidavit should be filed within a period of 3 weeks. Then, next panel. List the matter day after tomorrow to enable the PWD officials to provide answers as to whether 2 or 4 conveyor belts are to be installed in the arrival area, in the arrival lounge,
Yes. Arrival lounge 1 and arrival
in the arrival lounges,
lounge.
in the arrival lounges.
Obliged.
Obliged.
Item number 2.
Lordship, this is with regards to the 4 stretches of road.
Yes, force it.
Yes, Your Lordship, I have filed my affidavit in compliance to the court's order dated 10/6/2026 on 21/7/2026.
Yes, so what is to be done?
Yes, Lordship, as per the para 2I, if the Needy Creative Infrastructure Private Limited, if this contractor can be impleted,
For which road?
Aizawl to Kanhun via Mamid Road. They said that the road has been awarded to Needy Creative Infrastructure.
When was it awarded?
It is not given in the affidavit, Lordship.
Yes,
Only
yes, when did you allot the contract to that contractor?
Your Lordship, on 22/6/2026.
22/6.
Yes, Your Lordship, at Annexure 1.
Madam, they've just entered. You have to give them some working time. You can't
Okay,
expect
Lordship.
miracles.
Okay, Lordship.
22 June. You cannot have a wholesale PIL of the entire state. So what is to be done now?
Your Lordship, with regards to the Kanhun to Aizawl to Kanhun via Mamid Road, the expected time of completion is 2 years.
That's what.
And
But then I believe it's in a very bad condition. At least the videos that they show on WhatsApp I mean, the road conditions are very bad.
Yes, Lordship, we have personally visited Mahmud Road last week. It's in a very bad condition.
Anyway, but then the PWD were here, we let them off too soon. Where is your affidavit? 21st July, this one.
Yes, Your Lordship, 21st July 2026.
Yes, so what do we do with this PIL?
Yes, Lordship, let them carry on their work. If this can be kept in abeyance, then
We'll close this, you file afresh later on. What more do you, what more? Why should we keep it just like that? Yeah, your job has been done now, in a way. What about any Chinese here? Where is your status report?
May it please your Lordship, I am appearing on behalf of my senior, Mr. Samuel Vanashata, and in compliance with the order dated 10/6/2026, we have submitted our status report regarding policy to Bill Kotlir and Tlung Lei to Tlung Khung and Tlung Khung to Tlabung. So,
Where is your status report?
the affidavit in opposition was filed on 23rd/6/2026 in page 2, para 2. This is regarding the current...
No, wait. Let us see. We're looking for your affidavit. Where is your affidavit?
23rd,
here.
6.
Are they? It'll be part of this. Why is it separate? What has happened to this road between Sairang and Korpi? Is it still okay?
Lordship, it is written in the affidavit on page 3, column number 4. scheduled date of completion is 6 July 2026 for the Bilkotlir Kolosip area.
No, I'm not on that. I just said Sairaan to Konpui and you're talking about Bilkotlir and...
Yes, Lordship, because Bilkotlir Konpui is covered under Bilkotlir 2 Kolosip area.
Bilkotlir to Kolasip, how will Konpui be covered there? Konpui comes much before Kolasip.
Yes,
And
Lordship.
Kolasip comes before Bilkotlir.
Bilkotlir.
Then it's like saying Bokon comes within Durklang and Serchip or Sipir. How can it be? You mean to say it's one contract, is it? Anyway, I think we'll close this now. What do you want? What more do you want? We cannot keep monitoring this.
Yes.
They have given a status report. Right. Heard Ms. Rosalind Elmar, learned counsel for the petition. Also heard Ms. Caroline K. Lung Oipui, learned government advocate for the learned state government advocate. Also heard Ms. Zaire Sampui, learned CGC. For respondents number? 6. Ms.
Zodian Pui Taptok on behalf of Mr. Samuel Vanashata.
Appears on behalf of Mr.
Respondent 7.
Samuel Vanashata Changte, counsel for the respondent number?
7.
7. The present PIL pertains to the maintenance of 4 major stretches of road within the state of Mizoram. That is Aizawl to number 1, Aizawl dash Kolasip dash Tilcha Road via Durtlang. Number 2, Aizawl dash Kanmun via Mamit. Number 3, Lungle dash Tabung Road. Number 4, Lungle dash Chongte Road. In view of the very poor conditions of the roads mentioned above, this court had asked for the status reports with regard to the above 4 roads. Keeping in view the fact that money had been sanctioned for restoration of the above said roads. Pursuant to the directions passed by this court, the state respondents number 1 to 5 have filed an additional affidavit dated 21/7/2026, which is to the effect that the contract work for the Aizawl Kanmun via Mamit Road has been awarded to Nidhi Creative Infrastructure Private Limited, having its address at 4th floor Kuntila. It is here, I'll just put this, the red one. as per the agreement made between the state and the said contractor, the expected time of completion is 2 years, that is on 27/5/2028. It has also been stated that the contractor has already mobilized his assets towards the site and has started construction of permanent works such as Gabion wall, Gabion, Gabion wall, retaining wall and culverts. In respect of the Lunglei-Chongte Road, the stretch between Lunglei to Chumkhum, CHHUM, is under construction, is under NHIDCL construction, while the stretch between Chumkhum to Chongte is under Tlabung Division PWD. It has also been stated that immediate patch repair works and maintenance works have been undertaken by the Tlabung Division PWD. Though the road is, as the road is in bad condition, which is not being helped by the present monsoon. The next para, the additional affidavit filed by the respondent number 7, Executive Director (P) NHIDCL, is to the effect that is provided in paras 2, 3, 4 and 5 of the said affidavit, which is as follows. On considering the fact that works have been undertaken by various authorities in respect of the 4 major roads in the state of Mizoram, we are of the view that it would not be of any use to keep the present PIL pending any longer. We however hope that the authorities who undertake the contract work complete their work and restore the roads for all types of traffic within the stipulated time. The PIL is accordingly closed.
Item number 3.
Yes?
If your lordship permits, my lord, it may be taken up after a week, my lord. I've taken the consent of the
Okay, right, on
other
the prayer of the
party.
parties, on the prayer of the counsel for the
Appellant, my lord.
appellant, who submits that he has taken the consent of the other side, lists the matter. When? After a week?
After a week, my lord.
After a week.
Seek your lordship's indulgence. My lord, if I may be allowed to make a small prayer regarding item number 10 of part 2. My lord, the respondents and the appellant, they are siblings, and it seems that there's a chance of reaching an amicable settlement.
Okay, very
so,
good.
if this matter may be referred to mediation,
Mediation.
Yes, lordship.
Yes.
To be in the High Court.
Yes, Your Lordship, there is a in the
There's
High
a-
Court mediation.
There's a mediation cell here. There's a
Yes.
mediation.
Yes, Your
Yes,
Lordship.
lordship.
Okay, right. So, is there a secretary of the mediation center or what?
There's a mediation center.
Okay, right. Counsels for the parties submit that there is a possibility of settlement between the parties. Accordingly, the matter may be referred to mediation. In terms of the prayer of the counsels of the parties, a registry to send this matter to the mediation center / wing for attempting a settlement between the parties before a mediator. List the matter after? To list the matter after 3 months, 2 months?
No, Lordship, after
Oh, how?
1 week, because both of them are here in the ISO.
Okay.
After 1 week.
After list the matter, give a date. After 2 weeks, give a date.
18th of August.
Lordship, yes.
With my permission, may I mention a matter, my lords, for listing? My lords, there are 2 criminal appeals, my lords. I've been sentenced to 2 years convicted for 2 years only under conspiracy, my lords. One of the appellants, these are 2 criminal appeals and suspensions. My lords, one of the appellant's grandfather has passed away. My lords, I have a statutory right, my lords. May I seek my lords' indulgence for listing today urgently at 2 p.m.
You list the matter. Where is
At 2
the
p.m.
after part 1?
At 2 p.m., my lords.
After part 1.
And obliged, my lords. My lords, my difficulty is I'm being led by a senior counsel who may reach Aizawl only a little, maybe after my lords' board.
Who is the senior counsel?
My lords, he's on a flight right now to reach Aizawl. That's
Who
why I
is the
mentioned.
senior counsel? What is his name?
Mr. Jatin Sehgal. He's not senior designate,
Oh.
but he's senior to me, my lords.
He'll be here. Flight lands usually around 11. Now it's going to be 12. Yes, next.
Obliged, my lords.
My Lord, may I seek indulgence to mention part 2 item number 9. Which may this matter be taken up after 2 weeks?
On the prayer of
Petitioner.
On the prayer of the counsel for the petitioner.
Yes, my Lord.
List the matter after 2 weeks.
Much obliged.
Your Lordship, part 2, item number 5 has been fixed for today. I have submitted a mention memo yesterday for
You mean,
John.
what is that item?
Your Lordship, it may not be convenient
No,
for Your
no.
Lordship to take up.
No, this Jacinta also. Tunami Machi. What was the case number? 9. Look file. Show me the file. Just give me item 9. Just a minute, mister. I just wanted to see why is this. Is there some order I passed there? Part 2, no? Jacinta Tunaran, so item 9 more. Item 9. Yes, Mr. Amla.
Lordship, item number 5, fixed
Yes.
item,
Yeah.
fixed for today. In
Okay.
spite of that, Lordship, the
Item 5, just show me item 5. Part 2, item 5.
writ petition was decided by Lordship
Oh.
after the civil court had decided the civil suit. So there's a class. So-
So I cannot do that. Hey, part 2, no? Nitin, part 2 me khan law me impact item 9 ka.
Item 5.
Item 9 part 2 me be the part 1 not impact ka. This is Where is it? Where is the judgment? Which page is it?
It's an order dated 10/6/2025, which is impugned.
10/6/2025. No, you said that I had also
Yes.
passed an order. Where
Yes.
is that order?
Lordship, the judgment is in connection with WPC number 48 of 2010. It's in respect of the CIJW land acquisition matters.
My Lord, if I may, WPC 48 of 2020, that was filed by petitioner. Then, in the meantime, Union of India also filing WPC 19 of
And
2011.
another WPC
Then
19 of
White Common
2011.
Judgment has been passed by your lordship on 23/2/2017.
Okay, so I cannot take up this matter. Is it?
It may not
No,
be
my Lord, we are
convenient.
relying upon your judgment only.
Oh, so because of that.
Yes.
Okay. So where is that judgment? Is it here?
It's not in the judgment itself.
No. So why can't I take up? Why can't I take up the matter?
Lordship, I'm just bringing the matter to your Lordship. If your Lordship feels that,
I don't have any problem.
because this judgment was passed based on the judgment which your Lordship had rendered in those
The
WPC.
judgment that I passed has not been put to challenge. Has not been set aside.
It has not been set aside,
Then what is wrong?
but it may amount to your Lordship deciding your Lordship's own case.
Okay, how?
Because that judgment was decided by a Lordship
So?
in WPC,
So?
and based on that, the impugn order was made. And at the same time, there
Based
was a
on that,
decree.
so what is wrong?
There was a decree. There was a decree in favor of the plaintiff, and the plaintiff's decree was sought to be executed. In the process of execution, this judgment was introduced, and on the basis of this judgment, the decree was not taken into consideration. So I don't know whether Lordship would like to take up that matter.
I don't have a problem, unless you don't want me to hear the matter.
I feel that Lordship,
You file an application. I'm not going to. You cannot go bench hunting, Mr. Counsel. Bench hunting is not allowed. You file an application. I'll decide whether I want to.
I had filed an application yesterday.
Where is that?
Yesterday
Where is that?
for adjournment.
For adjournment.
Yes.
Okay, for adjournment. That's a different matter. For adjournment, okay, but don't say that you
I'm
should take up
I'm
this
not
matter.
hunting for any other bench. But I feel
Basically,
that
you are hunting.
I feel that the
hunting,
Lordship may not like to decide this matter.
No,
because
if I had passed an order and that order has attained finality, what is wrong?
There is nothing
it has
wrong.
attained
There's nothing
finality in that
matter.
writ petition.
Correct. So what
But
is wrong?
even the civil suit had attained its finality. There was a decree. When there is a conflict between the decree and the order passed in the writ petition,
I thought there is a conflict between the writ petition and a decree.
yes, Your Lordship. So naturally, Your Lordship is going to take side of the writ petition.
I don't know. We'll have to see. That is the way you look at it. That I will decide when I see it, whether there is any conflict.
So, in order to avoid that controversy, Your Lordship,
No problem if you want to adjourn. But you should have just said adjourn. When you say that you would not want to do it, I thought maybe there was some. I don't know, the conflict is not there. There is no conflict. There are many decisions where we have remanded the matter back to the thing, where the thing it comes back to us. We decide. There is no conflict.
anyway, Lordship,
On the prayer for adjournment made by Mr. C. Lal Ramdawa, list the matter after 2 weeks.
no plans.
For mission item number 1,
Left out from award. How does this? Yes, what is to be done here, madam?
Yes, Your Lordship, I am appearing on behalf of the State Respondents. Your Lordship, in our affidavit in opposition, in the last para, we have mentioned that in the last para, that is on page number 8, we have mentioned that the Senior Executive Engineer PWD in paragraph number 13, Your Lordship, we have mentioned that letter number so and so, the Senior Executive Engineer PWD National Highway Division 3 informed the District Collector Kolasip that with regards to compensation award caused by strengthening, widening, construction of NH 154 Bairabi to issue certificate interest calculation was made as per section 34 LA Act 1894 and no further compensation will be required. Now, Your Lordship, in this, and then in paragraph number 9, we have mentioned that the DC Kolasip via letter number 10/6/2025 sent a letter to the...
No. Let's, you see, the issue is,
Yes, Your Lordship.
what is his case? His case is that you have encroached upon his land
Yes, Your Lordship.
and you have constructed a road.
Yes, Your Lordship.
Is it?
Yes, Your
That's
Lordship.
his case. Now, what is your case?
Your Lordship, our case is that now he's basically... Your
No,
Lordship,
your
the
case
petitioner-
is that whether you have encroached or not. You have to give us.
Yes, Your Lordship, that it has been encroached upon. However, Your Lordship, the assessment has also been redone during the course of this petition, and then it was assessment was also made for him. However, his main grievance is regard to the fact that his land value was not being included in the assessment.
Land value. So this assessment is being done under what law?
1894, my lord.
Huh? 1894.
Yes, my lord.
LA Act 1894.
Yes.
Yes, Your Lordship.
When was the land encroached upon?
The award was issued In 2006, my lord.
2006.
2006,
Okay.
yes.
So, okay, so it is all right. Then if you are not satisfied with the amount, you file a section 18 reference petition.
No, my lord. At first, at the time of filing, we are not included in the award, my lord.
Correct. You're not included in the award.
Now they have conduct a spot verification without us knowing, and two of the petitioners are now included in the supplementary award. Yes, they
Okay,
have,
not all of you all.
Yes,
How many petitioners are here?
4, my lord.
4. So 2 are included in the supplementary award.
Yes.
And then now, and 2 have not been included.
Yes.
Correct?
Yes, my lord.
So now for those 2, why are there, so who are the 2 that are included? Petitioner numbers?
1 and 2 are included.
1 and 2 are included, 3 and
3
4
and
not
4
included.
are not included.
3 and 4 not included. Why? On the ground
This-
that your land has not been encroached.
No, my lord. They say that we have acquired the pass after the issuance of the award, my lord.
Oh.
But my for specifically for petition number 3, I have acquired my pass in the year 2004, whereas the award was passed in the year 2006, my lord. And however,
Let
my
us
lord-
see your pass.
Yes, my lord. My land pass is starting from page 15, my lord. And page number 20 is the pass for petitioner number 3, my lord.
Page
pass-
15.
Page 20 is the, starting from page 15 of my petition, my lord.
This person, Lal Oya, he's
Yes.
the petitioner number 3.
Number 1, my lord. Petition.
Mister, you take me to 3 and 4 only. I don't want.
Yes, my lord. Yes. Petitioner number 3 is from page number 20, my lord. Page number 20. Annex
Yes.
1B.
Page number 20. 2004.
Yes, my lord.
Now you see, these are questions of fact. Unless they agree to it. Is it, why, he's saying that his pass is 2004. And that is for petition number 3. And petition number 4,
I have no, petition number 3 is rightly, my lord. It is at 2008, my lord.
petition number 4 you mean.
Yes, 2008.
So this petitioner number 4 does not have any right. How can he be
Yes,
given
yes.
land after it has been acquired? That you cannot give acquired land after a road is constructed. You cannot be given land. Supposing
Yes,
that too you got no claim, correct? Supposing this road out here is given to you, will it be legal?
No, my lord.
No.
For petitioner number 4, I
No,
cannot make any further
no
submission,
claim.
my lord.
Okay. Only petition number 3.
Yes, my lord.
Only petition. So petition number 1 and 2, that has been taken care of by the supplementary award, correct?
Yes. Yes, but for the petitioner number
2.
1 and 2 also, my lord,
Uh-huh.
they were not given land value. Their respective.
That you, Mr. Counsel, please file a reference
Yes, yes, yes.
petition under section 18. Okay?
Yes, has been taken care of.
then
And only
taken care of
petitioner
then-
number 3. is
Petition
left
number
only.
3, yes. Madam.
Your Lordship, with regards to the specific petition number 3,
railhead bull.
Your Lordship, there is no specific mention in the verification and assessment done in 2024 regarding petition number 3. It is only with...
So you take a decision with
Yes,
regard to
Your
this. Take a decision. Because now you see, because it says a house pass. Now you take a decision whether this is fabricated or not a valid pass,
Yes, Your Lordship.
or that it has not been given by the VC or something, whatever. But if you find that it is a valid pass, then you
Yes,
pay
Your Lordship.
compensation.
Yes, Your
As
Lordship.
per the alia Act, that's all.
Yes, Your Lordship.
So we'll ask you to take a decision, and if it goes against him, then you file a civil suit, because you will have to prove the thing.
Yes, madam.
Okay, right. Heard Mr. Lalbi Agnunga Namte, learned counsel for the petitioner. Also heard Ms. Lannundui, learned counsel for the
2 to 5.
Before that, Ms. Zairem Sangpi CGC, appearing for respondents number 1. Ms. Lannundui appears, government advocate appears for respondents number
2 to 5. 2 to 5, Your Lordship.
The case of the 4 petitioners herein are that they are owners of land located in Bairabi village, Kolasib district. It is the case of the petitioners that on 4/1/2006, a notification under section 4(1) of the Land Acquisition Act 1894, hereinafter referred to as the LA Act, was published by the respondent number 5, inviting objections in connection with acquisition of land for construction of a two-lane road, correct? Road.
Yes, madam.
Along National Highway 154, stretch 53.000 km to 58.000 km, Bairabi, Kolasib district. Next paragraph. It is the further case of the petitioners that the state respondents published award. Where is the award page?
Page 32.
Published award. 32. Published award number 1 of 2006. Under the LA Act, wherein lands were acquired for construction of the two-lane road. The names of the petitioners were, however, not mentioned in award number 1 of 2006. Being aggrieved, the 4 petitioners have filed the present writ petition. Pursuant to a spot verification conducted on the lands of the petitioners Where is the spot verification report?
Your Lordship, that is on page number 35 of the affidavit in opposition filed by the state. It was conducted, the report is of 8 April 2024, page number 35 of the affidavit in opposition, Your Lordship.
What? Which 8? Which date?
8 April 2024, Your Lordship, that is the verification and assessment record. And
Page 35?
Page number 35, Your Lordship, of the affidavit in opposition. And the joint verification and assessment was done on 23rd and 25th.
No, page 35 is not the verification report.
36, Your Lordship, that is verification assessment report on missing plot structures for the purpose
There
of...
is no page 36. Oh, you don't. Oh, say additional. 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 Please show them where is the verification report. What page is that?
24.
You were saying 35?
Yes, Lordship, on mine it is 20.
On yours, Madam, please paginate your pages as per the court.
Yes, Your Lordship.
Pagination. When you say 35, I go to 35 and it's actually 24. Right. Pursuant to a joint verification made with regard to the claim of the petitioners. Pursuant to a joint verification made by the state respondents on the grievance of the petitioners, where does it talk about your thing? Where does it, this joint verification, where does it speak of petitioners number 1, 2, 3, 4? Where does it speak of them?
At their apportionment sheet, my lord.
No. Where does the verification report speak about you? Where is your name?
No,
Nothing
my
is
lord.
there.
Nothing is there, my lord. But petitioner number 1 and 2 were mentioned in serial number 27 and 35 of the apportionment sheet, my lord. In continuance to the spot
Okay,
verification.
right. Pursuant to a verification made on the grievance of the petitioners and a number of other persons whose lands were allegedly used for construction of, were to be used for construction of a road, comma. The verification. Now, the verification reports an apportionment sheet made in pursuance to the verification report showed that the petitioners number 1 and 2 were entitled to be given compensation as the road to be constructed was to pass over their lands. Full stop. The next paragraph. The petitioner's counsel submits that in view of the above facts, the petitioners number 1 and 2 do not wish to press the present writ petition any further, as they have been identified as persons who would receive payment in terms of the supplementary affidavit, a supplementary award. Supplementary award made or not?
We have only seen this apportionment sheet, my lord.
Madam, is the supplementary award going to be made?
No, Your Lordship, not to my knowledge, it has not been made.
Why?
Your Lordship, the only information that I have is regarding is limited to the verification and assessment report.
This assessment report
Yes, Your Lordship.
is you are paying them for what? For what is the reason you are paying them?
Your Lordship,
For
this
cross value. How can you just pay them money on what grounds? What is your LSC? Your LSC or VC pass?
VC pass, my lord.
House pass?
House pass.
The- So what have I said? No, don't say that. Just cut. Come here, mark it. And a number, a, not the. Compensation for damage to their crops. Was to pass over their lands. No, passed over their lands actually. Passed over. Already road was constructed, no? Passed over their lands. Okay. First. Have you been given the money?
No, my lord.
What is happening? Who is the authority who made the road?
PWD.
Huh?
PWD North Division, my lord, I think. It is, they have their headquarters at Thingdol. PWD.
National Highway Division 3, Your Lordship, that is as per the petition. Respondent number 4, Your Lordship, that is the
No, madam, just answer one question. The land has been used for a construction of a road, correct?
Yes, Your Lordship.
So the entire land has been taken away.
Yes, Your Lordship.
If that is taken away, then why haven't you paid the money? And when was the verification done?
This was Your Lordship, that the verification was done because complaints were sent in, and this
When
was
was it done?
conducted
When?
in 2024, Your Lordship.
You don't know the date. It is the year 2024, that's all.
Yes, Lordship, that is after the complaints were submitted to the DC office. That is as per whatever has been written in the 2024 assessment, Your Lordship.
Now, why have you denied number 3, though you do not know? Any reason given?
No, Your Lordship,
Petition
no
number
reason,
3?
no specific reason has been given for petition number 3.
Petition number 4?
Petition number 4 also, Your Lordship, no specific reason has been given.
Just now they are saying that the pass was issued after the land was acquired.
Yes, Your Lordship.
You'll have to pass a supplementary award. They are entitled to not only, they are entitled to interest, solatium. So what have I said? No, cut that. Before that, what was the sentence? Persons. As the road that was constructed passed over the lands. Full stop. As per the apportionment made pursuant to the verification report, petitioner number 1 was to be given compensation for crop damage amounting to rupees. We are taking forever.
136978.
While the petitioner number 2 was entitled to rupees.
41834.
How much?
41834.
41834. Full stop. Next para. The petitioner number 3 was, however, not found to be eligible to be given any compensation, for reasons not provided by the respondent. In respect of the petition number 4, it is quite apparent that the said petitioner cannot have any claim for compensation for acquisition, inasmuch as the land for the road had been acquired in the year 2006.
Yes.
While the land allotment by the village council on the land acquired for the road had been allotted in the year 2008. Wide VC pass number, where is that again? Page?
VC pass number at page
23, Your Lordship, of the petition.
Yeah, wide VC house pass number 315 of 2008. Dated 1/7/2008. Next paragraph. Yes, but any submissions to make?
Your Lordship, at this stage, Your Lordship, I would like to state that as per mentioned in the writ petition, this assessment, at the stage of when the petition was filed, There was no assessment made, Your Lordship. Only in 2024 was the first assessment made based on the complaints of the several landowners, Your Lordship. That is my submission. And Your Lordship, other than that, Your Lordship, my submission is that the finding in pan number 6, that is page number 26 of the additional affidavit, it states that
Yes, sir. Page number 26.
26 of the additional affidavit, Your Lordship.
Your page 26 will be my page.
No, Your Lordship, I have calibrated, so
26,
it will be
yes.
26 for you. So, Your Lordship, that is pan number 6, Your Lordship, that is the finding of only the respondent number 1.
Respondent number
Sorry, Your Lordship, petition number 1.
Petition number 1 and 2.
Yes, Your Lordship, that is the only finding that is there. For petition number 3, there are no specific findings.
Where is petition number 1 in page 29? You are so unprepared, my God. Mr. Counsel, in that apportionment sheet, where is petitioner number 1?
Petitioner number 1 is at serial number 35, my lord.
And petition number 2?
Is at serial number 27.
Right. The verification and assessment report with regard to landowners whose names were not included in award number 1 of 2006 states at para 6 of the said verification report as follows, page 26. The apportionment sheet for payment of the additional compensation to landowners whose names were not included in award number 1 of 2006 shows the petitioner number 1 to be at serial number 35, while petitioner number 2 is at serial number 27. The apportionment sheet shows that despite being given compensation for crop value, they are also going to be given 30% solatium. Next paragraph. As the acquisition of the land had been made in terms of the alia Act, and as the petitioners number 1 and 2 were not included in the original award number 1 of 2006, the state respondents would have to issue a supplementary award under the alia Act 1894 for payment of compensation to the petitioner number 1 and 2. They should also look into the issue of whether the petitioners would be entitled to be given compensation for land value and interest at the rate of 12% besides the solatium granted to them. Full stop. Next paragraph. The petition number 3 claims to be the owner of land covered by village VC house pass number
219 of 2004.
219 of 2004. However, the respondents have not given any reason as to why the petitioner number 3 is not included in award number 1 of 2006, and the fate of the claim of the petitioner number 3 at the time of verification undertaken in respect of those persons whose names were not included in the award number 1 of 2006. While petition number 1 and 2 have found place in the apportionment sheet, the petition number 3 has not found place, has not been mentioned in the apportionment sheet. The deputy commissioner, the district collector, which area, which district? Colosseum, shall accordingly make an inquiry and take a decision as to whether the petitioner's village council pass is a valid or is a valid house pass or not, valid VC house pass or not. If the district collector comes to a finding that it is a valid house pass, the petition number 3 would have to be given compensation if the road has been constructed over the house village VC house pass number
219 of 2004.
219 of 2004. Full stop. The said exercise should be concluded within a period of 2 months from the date of receipt of a copy of this order. Next, with regard to the claim of the petitioner number 4 for compensation, the very fact that his claim to the land is based on a village council pass issued in the year 2008, that is after the land for the road had been acquired in 2006. There is no case for grant of compensation to the petitioner number 4, inasmuch as he cannot be the owner of the land after the land had already been acquired for construction of a road. The Deputy Commissioner should take steps for issuance of a supplementary award and payment of the compensation that the petitioners are entitled to, petitions number 1 and 2 are entitled to, within a period of
2 months, Your Lordship.
2 months. The writ petitions accordingly disposed of.
Deeply obliged, madam.
Item number 2.
May it please Your Lordship.
If I occur in the hall, pause this or make it pause this. Yes, what is this?
Lordship, we have received affidavit in opposition from respondent 1 to 4 and 5. So we would like to seek 2 weeks time to find rejoinder affidavit.
Mr.
Stephen Lalbuatsaya.
Huh?
Stephen Lalbuatsaya.
Stephen Lalbuatsaya, counsel for the petitioner, is granted a further
2
how much
weeks'
time? A further 2 weeks' time to file a joinder affidavit. List the matter after 2
And
weeks.
Lordship, in the meantime, if interim order passed earlier, may be
Interim
continued.
order to continue till the next date.
Till the next.
Oblige.
Item number 3.
My Lord, I'm standing on behalf of my senior Lord Sailau. In the present case, my Lord, my senior counsel will appear on behalf of respondent number 8. Since he is unable to come to this honorable court, my Lord kindly seek time to file vocalant nama on my senior on behalf of respondent number 8.
What is the senior name?
Lord Watpuya Sailau.
It is submitted that Mr. Lalbuatsaya Silo will be appearing for respondent number 8 and filing a wakalatnama within a week. List the matter after a week. This is your compensation. Ombudsman has already taken a decision.
Lordship, yes.
Then
Lordship, this is the second round of the writ petition. In the earlier writ petition, in the same subject matter, since there was an ombudsman clause, and I was directed to approach the ombudsman, and the ombudsman had dismissed the representation filed by the petitioner, Lordship.
so what claim can you have? You have left that
Lordship,
village
this,
long
I
time
have a
back.
landed property, and this is regarding the Sermon village, and that was extended for the Dampa Tiger Reserve Sanctuary. And I have a landed property, and I have a house. And the reason why I was not given the
What did
compensation
the
was that
ombudsman say about the house?
Ombudsman says that since during the time of this verification, I was not in the said village. That was admitted fact, Lordship. I was not in a village due to my this profession. I was a driver by profession.
Your house will be what house will be? Thatched house or a concrete house?
It's not a concrete house, Lordship. It's a kacha
Kacha house. Made of what?
made of this bamboo and it's kind of that.
Made of bamboo.
Oh, Lordship, yes. It's not a concrete building. And Lordship, there was a provision. There is two options, and option one is 10 lakhs for the relocation. Then I'm claiming 6.5
You have already
lakhs.
relocated, Mr. Counsel. Where is the case? You have already relocated.
I was relocated without giving any compensation. Since I have a landed property,
You have already left. Where is the question? You know what relocation means? Relocation means when you are uprooted from one place and taken to another.
I agree, Lordship.
You have already gone.
Lordship, this, as per this provision in the sense that there are two options. One is those who are having those who are living in that village, and the
those
second
who are
option
having
is
property.
yes, property. So I have
Anyway,
property.
this is the matter after 2 weeks. Because he is going to come, his senior.
Yes.
Item number 4.
What is to be done?
Lordship, as per the last order dated 24/4 of 26, we have taken a fresh step against respondent number 3. However, Lordship, no service report has returned till date.
I'm for the respondent 1, my Lord, claimant.
ID card from respondent number 2 is still awaited.
Yes, Lordship.
3. You have taken fresh steps when?
On 11/5/2026.
So now 2 months have gone.
Yes, Lordship. Lordship,
You can argue the case. What is the case?
it's make appeal.
Is it?
Yes,
Okay.
against
What is the ground of challenge?
the grounds have been mentioned on page number 9.
Are you ready to argue?
No, Lordship, just if Your Lordship may direct the registry to check the consignment of the service. If your Lord,
My lords,
we
they are
may-
raising mainly on the quantum and they are trying to shift their liability on the driver
The
of the...
problem is his senior is not here, that's what. And
Yes,
I
that's
think
Your
the
Lordship.
presence of the respondent number 2 will be required because they are shifting their liability on the driver of
ID
the...
card is still awaited from respondent number 2. What to do?
Lordship, if the registry may be directed to check the consignment.
When was notice sent to the respondent number 2? Notice was issued in 25. You take fresh steps on respondent number 2.
3.
Okay, right. Office note indicates that there is no return of AD card or unserved notice from the respondent number 2. Further, there is no service report with respect to service of notice upon the respondent number 3. Appellant to take fresh steps for service of notice upon the respondent number 2. Lists the matter. No, the steps to be taken within 2 days, lists the matter. After a month, you would it.
Eighteenth of August. Item number 5.
Please, Your Lordship. As per the last court's order, the notice issued upon respondent 3 and 4 have returned unserved, stating that it's for respondent 3 it's an incomplete address, and for respondent 4 no such person is in this address. So
This surfacey order
yes, madam.
has been issued when? Which date?
I believe it's on 18th of. Let me just check. Hello.
Huh?
18/7.
18/7/2024. 4. But the order of the trial court is in 23, it's prior to that. So why should this matter be dismissed?
I have no idea regarding that.
You've got no idea with regard to the merits of the case. Okay, right. So who is respondent number 2? You are for whom?
Respondent number 1.
Respondent number 2, it says Lal Ompuya and Lal Chafam Kima have entered appearance by filing Vakalatnama for respondent number 2.
Yes, my lord. So, my lord, notice for respondent 3 and 4 still return unserved. So, if 2 weeks time may be given to verify their address.
Right. Mr.
Bensa.
appears for the petitioners. Mr.
Stephen Albuasea.
Steve Analbatsai appears for respondent number 1.
Yes, ma'am. Vakalanma was filed yesterday.
No one appears for respondent number 2, even though office note indicates that Lal Ompuya and Lal Chafam Kima have submitted wakalatnama on behalf of respondent number 2. There is no. Office note dated 18/6/26 indicates that, states that notices issued upon respondents number 3 and 4 have returned unserved with postal remark, inverted commas, RTS, full stop, incomplete address, and inverted commas, no such person in the address, inverted commas close. In view of the above, the petitioner shall obtain the correct address of the respondents and take steps for filing, take steps for service of notice on the corrected address. Who is appearing for 5? Mrs.
The state is made as a party, respondent number 5.
Ms. Linda L. Fumble, additional lady, appears for respondent number 5. List the matter, give a date.
20th August.
Take steps within, you do it fast.
Yes, Your Worship.
Item number 6.
Yes. What do you want out here?
We have a very limited prayer, my lord.
Yes.
We praise for spot verification, and if our land is indeed damaged, so and proper compensation may be paid to us, my lord.
You submitted a representation?
Yes, my lord.
They didn't answer. Did they answer?
Yes. Pursuant to my representation, my lord, one spot verification was conducted.
Oh, was done then?
Yes.
Where page?
At page 30, my lord. Page 30 of my petition.
Page 30?
Yes.
Page 30.
However, no further action was taken after that.
Page 30. Where page 30 is what? Page 30 is this.
Page 30 of my...
Mr. Counsel, we have to have the same page. Page 30 of your petition. Okay,
Yes,
page 30. Okay, sorry, that was the I. Okay. Page 30. Page 30 is list of complaints. This thing.
Yes, the complaint related, it is the letter written by Deputy Commissioner in Kala Lunglei District.
Page 30?
Yes, 30.
That is page 29.
Oh.
26 October.
Yes, my lord.
Page 29. Annexure 7.
Annexure 7, my lord.
Please give us, please paginate correctly what is going on in this court.
I apologize, my lord.
Yes.
And the
number of have been where is your name in
my
this
name is
list?
at serial number 11, my lord. Ram Lune is my late wife.
You have got no case here. Verification has been done.
Yes, my lord. But no further action was taken, my lord.
What action is to be taken? This is your land, not their land. What action do you want?
For payment of necessary compensation.
Where is
my
the
lord.
question of payment? Since it says here, since a structure building falls outside ROW. What is this ROW?
Right of way.
Huh?
Right of way.
Right of way. Action to be taken by ABCI. What is this? What is this? What action is to be taken?
Your Lordship, that this the ABCI is the contractor. They were supposed to build a retaining wall, I believe, Your Lordship.
Your case is what? That the building was demolished?
Yes.
By whom?
We are instructed by the contractors to demolish my 2 buildings. And also, my lord, my land was cut off by the construction, said construction, my lord. My land was damaged, my lord.
Damaged?
Yes.
But your land was not used, but your land was damaged.
Yes.
Huh?
Yes, my lord. Portion of my land was cut for the construction of the said road, my lord.
Portion of the road.
Yes. Portion of my land was cut.
But they are saying this. Yes.
Yes, my lordship. Yes, your lordship. I am for the respondent 3 and 4, and we are the executing contractor. And whatever allegations they made, it's wrong. We never go beyond the contract. We carried out the work within the approved and handed over right of way.
So you did not demolish?
Yes. And in fact, while acquiring the land, there is no permanent building situated over the land which they made the allegation. A small bamboo shed was there. And that is situated 5 meters beyond the right of way.
Have you filed affidavit to that effect? You have filed your affidavit?
No, lordship.
You have not filed any affidavit. Why? You are for respondent number?
For 3 and 4.
3 and 4.
Yes. Well, the affidavit in opposition, yes, your lordship will file.
You have filed?
Yes.
Another thing, okay, so you have denied completely.
Yes, your lordship.
So this is a question of fact now. Now the
Yes,
question
Your
is, this page 31, why is it incomplete? There's something missing at the bottom. Page 31, serial number 11, in the second last column. Where is it? Where is the complete portion?
Your Lordship, as per I'm representing Kala Ilungle, Your Lordship, what they've informed me is that this in this particular verification, they have stated that the ABCI is supposed to construct a retaining wall. That is what has been said in this verification.
Okay, this last line is missing. I don't know.
Yes, Your Lordship, it says that the ABCI is to construct a retaining wall. That is all, Your Lordship.
ABCI project manager promised to start what?
Construction of retaining wall.
Is it? That's
Yes,
correct.
that is what I've been. Yes.
Where do you get that?
Your Lordship, I got it as per verbal instruction that I've.
Yes. Why are you not? Why are you hiding facts from this court?
No, my lord. We are not hiding facts, my lord.
No. Then you should give the entire correct the entire thing.
That is what we have received, my lord.
Anyway, no case.
And also, my lord.
You see, it has been denied.
Yes.
Your case is that they have encroached upon your land. Their case is that there was no encroachment upon the land, and the verification report also showed that there was no encroachment. Now, if you are aggrieved with this, you go to civil court.
Yes, my lord.
You go to civil court. So either I dismiss or you withdraw. What do you want?
I may be allowed to withdraw, my lord.
Heard Mr. Lalbia Nunga Namte, Learned Counsel for the petitioner, who submits that he may be allowed to withdraw the writ petition. to enable him to approach the appropriate civil court. Ms. Lalnunri, Ms. Zairem Sangpui, CGC appears for respondent number 1. Ms. Lalnunri appears for respondent number
5, Your Lordship.
5. Ms. Rishila Thapa appears for respondent number 3 and 4.
Number 3 and number 4.
Who is for 2?
Your Lordship, I'm appearing on behalf of my senior Samuel Valercieta.
What is your name?
Philip Van Malsoma.
Mr.
Philip Van Malsoma.
Philip Van Malsoma appears on behalf of respondent number 2. The prayer of the petitioner's counsel is allowed. Writ petition is dismissed as withdrawn, with liberty as paid for. Now you have to go because they have denied your thing.
Yes,
Item number 7 for orders.
Yes.
Yes. The respondent number 2 is yet to be represented, and though they have prayed for time for filing Vakalat Nama and objection, they have not filed any till date, my lord.
Who is this R. Kerala Rinsangi?
That's one of ours.
One of your friends.
Yes, Your Lordship.
She was supposed to file Vakalat Nama. She has not filed it.
Lordship, there was some, we were waiting for some instruction from our clients. So,
Material instructions.
they were planning to take this legal counsel.
Okay.
So we were waiting for that, but last moment they told us to represent them. So we were waiting for them for maybe 2 weeks. So now we will be filing our representation along with our
You will be filing a Vakalat Nama.
Yes, within 2 weeks.
For respondent
For
number
respondent
2.
2.
Okay, Mr.
Lalven Sanga.
Alvin Sanga submits that he will be filing Vakalat Nama on behalf of respondent number 2 within 2 weeks.
2 weeks.
Along with
objections.
written objections. Miss
H. Lerausangi for respondent number 1. And I've already filed my objection, Madam.
Miss H.
H. Lerausangi.
Lal Rosangi, appearing for respondent number 1, submits that written objection has already been filed. Yes, Mr.
Vanal Trampuya for respondent number 4, and we also have filed a written objection in the IA.
Mr. Vanat Tranpuya for respondent number 4 submits that written objection has been filed. List the matter on after 2 weeks.
13th of August. Item number 8.
Please, Your Lordship. My Lord, there is a delay of 299 days in filing the instant review petition, my Lord. The reason being is that, my Lord, we have approached the Honorable Apex Court. And we have approached the Honorable Apex Court. And the Honorable Apex Court, there was a delay application that was condoned. However, the appeal that we have filed was dismissed, and we were given liberty to approach this Honorable Court for filing the instant review. And we have, and another ground is that, my Lord, we have...
No, Mr. Carlson,
yes.
let us be very clear. We are filing a condonation of delay application. Why?
My Lord. My Lord,
against what order?
The order, my Lord, the order is 24. The order passed on 21st 06/2024.
Where is that page?
My Lord, the impugn order, my Lord, that is not, we have not annexed in the IA. We have stated it para number 1, my Lord.
Yes.
And
No, you are challenging the judgment and order dated
06/2024. And there we have challenged that before the Honorable Supreme Court.
Huh?
We have challenged the order. We have firstly challenged this order before the Honorable Supreme Court.
Then?
And my lord, we have filed that on 25/10/2024. And my lord, the Honorable Supreme Court finally dismissed the appeal. My lord, that is on 24/02/2025. And we have applied for certified true copy of the order of the Supreme Court, and also we have the brief of the case, my lord, that was sent to us by post. And that basically, my lord, that is why there is a delay.
How do we know that it was sent to you by post? Where is the tracking details?
My lord, tracking details, these are not annexed in the annexures.
How do we know that the postal delivery took a long time?
My lord, we have mentioned that at page number 6, para number 4, Roman 4. Certified true copy of the order 24/02/2025 was received by the applicant number 1 through registered post on 03/04/2025.
Where is the proof of that? Where is the postal receipt
My
for
lord,
the track record, the track?
We have unfortunately not annexed the postal receipts.
Yes.
Yes, my lord. The Honorable Supreme Court has passed an order on 24th of February 2025. And then the appellants have also knowledge about this order. And then they have also applied for certified true copy, which was issued on 21st of March 2025, that is after 1 month. And then even though they have contended that the certified true copy was received on 3rd of April, the contents in the order that they can obtain from the Supreme Court website and the certified true copy of this order is the same. So my question is, what did they do after they have the knowledge of that order on the month of February?
They were waiting for the postman to come to their house.
Yes, my lord. So for this, a person who has acted promptly would have already called for a meeting, because there were 9 applicants in this case. So they would have already called a meeting even before those certified true copy were received by them. And then as soon as those certified true copy was received by them, then they would have filed this review. So according to me, the explanation offered by this applicant does not constitute a sufficient cause, and it is liable to this application is liable to be dismissed. And my lord, I have one Supreme Court judgment that I have relied on. Even though your lordship is well conversant with what is sufficient cause, I would like to place before your lordship. If I may take your lordship to paragraph number 9, sufficient cause. With your lordship permission, if I may read it out. Sufficient cause is a cause for which the defendant could not be blamed for his absence. The meaning of the word sufficient is adequate or enough, inasmuch as may be necessary to answer the purpose intended. Therefore, the word sufficient embraces no more than which provides a platitude, which when the act done suffices to accomplish the purpose intended in the facts and circumstances existing in a case, duly examined from the viewpoint of a reasonable standard of a cautious man. In this context, sufficient cause means that the party should have not acted in a negligent manner, or there was a want of bona fide on its part in view of the facts and circumstances of a case, or it cannot be alleged that the party has not acted diligently or remained active. Now, in the explanation offered by the applicants, they have not explained 51 days.
You should read para 11.
Yes. The expression sufficient cause should be given a liberal interpretation to ensure that substantial justice is done, but only so long as negligence, inaction, or lack of bona fides cannot be imputed to the party concerned. whether or not sufficient costs have been furnished can be decided on the facts of a particular case, and no straitjacket formula is possible. Yes, my lord. The explanation offered by the applicants, they have not explained 51 days. That is from the pronouncement of the order, that is 4th February 2025.
There's 299 days delay.
Yes.
Why 51?
So
why have you reduced it to 51 days?
No, my lord, it is that they have filed their SLP before the Supreme Court. So, understanding their situation, even after passing the order and the Supreme Court has given them liberty to file the review, still there is 51 days that is unexplained by them. So, there is grave negligence on part of the applicant, and this application is liable to be dismissed. That is my humble prayer.
51 days, only 51?
No, they have actively participated in, they have actively pursuing their case before the Supreme Court. Now, they know that the order was pronounced, they were given liberty to file review. But only after they receive certified through copy, they have decided to call for a meeting, and then after 5 days, they only engage their counsel.
Okay, so
yes.
What is the order that is under challenge?
The order that is, first in the trial court, money suit was filed, where I was liable to was imposed on me that I should pay certain amount.
RFA.
In RFA, the judgment order of money suit was set aside.
21/6/24.
Yes, my lord.
Is the order under challenge, correct?
My lord.
Here. So this is RFA 12 of 2022.
My lord.
Now SLP was filed when? On 21/6.
My lord, SLP was, yes.
Is it?
It
cannot
filed
be
on 25/10.
Huh?
25/10. Annexure number 1, page
SLP
11.
on 25/10.
25/10/2024.
24. Then you have filed the present appeal when?
My lord, present appeal is filed on May 2025.
May 25.
Yes. And I was approached by all the petitioners here in my lord on 24/04/2025. My lord, the fact that the
So SLP was decided when?
SLP was decided on 24/02/2025.
24/02/25.
Yes.
And you filed the present review petition. Review?
My lord. My lord.
Review petition you
yes.
filed in May 25.
My lord. My lord, the reason why we have filed the review is that the learned trial court had directed both the respondents number 1 and 2 to jointly pay up.
What is the limitation period for filing a review?
30 days, my lord.
30 days, my lord.
30 days. So from where are you counting these 299 days? From where?
My lord, we are counting from 21/06/2024.
From 24?
My lord.
So you see, from 24 if you are counting, and you have filed this on May 25.
My lord, that is as on 15/05/2025, date of filing. 15/05/2025. And if I may take your lordship's kind attention at page number 13, annex 2.
We'll
there
take
is-
it up at 2. At 2.
Yes.
May I seek a Lordship indulgence? Lordship, I'm so sorry to inform this court that the leading counsel has some family emergency and went home. So if the matter can be passed over for a day. My lord, if we look at the causes, there are 6 learned counsel representing the applicant. So just because of non-availability of one counsel, the matter cannot be adjourned, my lord. Because
Just for a day,
submission has
Lordship.
already made on behalf of the applicants.
You have to accommodate sometimes.
Yes, my lord.
On the prayer for adjournment made on behalf of the applicant's counsel. List the matter. Next week.
Tomorrow, my lord, if possible.
Next week.
Okay, my lord.
Duly obliged.
Item number 9.
My lord, as per the office note, the service
Item
report
number?
is still awaited from the respondents number 2 and 3.
Yes.
Your Lordship will be presenting respondent number 2.
Any objection to the delay? 149 days. Is it? 149 days.
Yes, my lord.
Any objection?
We'll be submitting it along with the written objection.
Okay, Mr. Lalvena submits that he will be appearing for respondent number 2.
Yes, my lord.
And I'm appearing for respondent number 1, my lord.
Miss
H. Rausangi.
appears for respondent number 1.
I have already filed my objection.
The counsel for the respondent number 2 is granted 2 weeks time to file an objection. This is the matter after 2 weeks.
Obliged, my lord.
Item number 10.
My lord, here I am for the applicant, and there are 7 respondents. Out of them, respondent 1 to 5 and respondent 7 is represented. And with respect to respondent number 6, my lord, ID card has returned back on 14/7. So if notice may be deemed complete. And in this IA, my lord, I have received a copy of the objection filed by the respondent 7.
My lord,
Who has filed an objection?
I'm already filed my objection.
For
respondent number 7, insurance
you?
company.
My lord, I'll be filing within this week written objection for respondent number 1 to 5, my lord.
Okay, counsel for the respondent number 1 to 5 submits that written objection will be filed within this week. As per office duly signed AD card has been received from respondent number 6. Accordingly, respondent number 6 is deemed to deserve notice. This is the matter. Next week. Date.
6th of August.
Obliged.
Obliged.
Item 11.
Lordship, service upon respondent number 5 has not been returned yet in this matter.
Yes, so what is required now?
If your Lordship permits, serve notice through the ST.
On respondent numbers?
5.
Right, there is no return of AD card or unserved notice from the respondent number 5. Appellant is allowed to serve notice by dusty service on respondent number 5 within 2 weeks. This is a matter for 2 weeks.
Obliged.
14th of August. Item number 12.
How much time?
Lordship, in the IA number 47 of 2026, We would like to file a written objections. If
How much time? How much
kindly grant
time?
2 weeks.
Respondent is granted 2 weeks time to file an objection. List the matter after 2 weeks.
Obliged.
Duly obliged.
13th of August. Item 13.
May it please your Lordship.
Yeah.
Lordship, this is a 483 bail application whereby the petitioner was arrested on 28th of June and as on date it has been 30 days he is on custody. Lordship, the allegation is that 837 grams of heroin was recovered from the petitioner. Lordship, kindly call the case diary, Lordship.
No. You tell me why should I call the case that? Tell me tell me one reason why you should be granted bail right now.
Lordship, as because no ground of arrest was communicated to the relatives and family members of the petitioners in writing, Lordship.
Let us see your petition.
Lordship.
And have you read the latest judgment in the Supreme Court in matters relating to commercial quantity cases? The paramount consideration required is the twin conditions under section 37 have to be fulfilled, not the other parameters. I think the judgment was passed last week.
Lordship, I have to go through the judgment. I have to go through the judgment.
It is already there. Ms. Linda, can you bring the CD day after tomorrow?
My lord, I'll try.
Day after tomorrow.
My lord, may this matter come up on 4th of August. My senior will be physically.
No. Yeah, right. This is an application for grant of bail pertaining to the seizure of 836 grams of heroin on 28/6/26. The reason for bail is on the ground that the grounds of arrest have not been communicated to the family of the petitioner. Mrs. Linda L. Fumble, edition PP, shall produce the case diary by on Thursday. This is the matter on Thursday.
Item 14.
Item 14.
May it please your Lordship. Lordship, today was fixed for questioning the engineer, Lordship. The engineer was called for clarifying the matter, Lordship, regarding the project.
Yes. Where is Ms. Vaneshami?
I think she's outside, my lord. Even the official has come.
I don't understand this case. He says there is encroachment. You all are agreeing that there is an encroachment. He knows that something is going on in his land. Some work is being done. You are not objecting also. Or you are objecting?
Regarding what, Lordship? Regarding the retaining.
Regarding the issue here.
No, we're not objecting the project, Lordship. But the only issue is the Lordship. The excavation was done encroaching our land.
But you're not objecting to the project.
No, the only issue.
What do you mean?
What I'm trying to state here is, Lordship, let it be done for the public purpose. However, it should be done within the government land. Should not encroach our land. If the respondent wants our land, if it requires, Lordship.
So the issue is simple. You don't want your land to be affected.
Yes.
Touched.
Yes.
But you are saying that it's touched.
So, Lordship, what happened was that.
Now, if it's touched, then what do you want? Supposing your land has been excavated,
yes, Lordship,
or some work has been done on your land, then what do you want?
Lordship, what we want is that if the land can be restored in its original state.
It cannot. You are saying that That is what you see, please make up your mind.
Yes, Lordship.
You said you don't want to stall the project because it's for the public good.
Yes, Lordship.
So basically, what are you trying to say? I don't know. It could be that you're trying to say that it should be acquired if it's.
So, Lordship.
I don't know what you want. You also don't know what you want. Yes. Take your breath. Take your breath. Take your breath.
No.
Let's call your official.
Yes, Your Lordship.
Yes, now is the land of the petitioner being encroached?
As per the report, Your Lordship, it is not encroached.
It is not being, it's not touched.
Yes.
Then, end of the matter.
Lordship, the issue is that, Lordship, it shows that, Lordship, as per the Lordship, as per the records and as per the spot verification which was done, and the amount of land which has been excavated, Lordship, it clearly shows, and it shows in our LSC as well that it has been encroached, Lordship. So,
Show me the verification report.
No, Lordship, we do not have the verification report because it was done. He was just called, Lordship, by phone call. He was told to come to the site to be present while the verification was done. However, we do not receive any report.
So this project is regarding construction of what?
Retaining wall, Lordship.
Retaining wall.
Initially, it was we were
retaining
informed.
wall is being constructed for what purpose? To prevent landslides
Yes,
in that
Lordship.
area. Huh?
Yes, Lordship.
Now it's being done by whom? Which department?
The exact reason is that, Lordship, when we filed the representation and before filing the representation, we were unaware which department it was, which is the reason why we approached the DC. And after since there was no reply from the DC, Lordship, we approached this Honorable Court, Lordship. And we even before filing.
So is it your case that you don't know who is doing it?
Lordship, we asked.
You see, Mr. Counsel, just answer it.
Yes, Lordship.
It's like this. Is this black or is this white? It's
Yes,
black.
Lordship. Yes.
Now the question is, do you know which department is doing that work?
Lordship,
If you know, you know. If you don't, you don't know.
Lordship, we do not know, Lordship.
See that simple. What is? You don't have to go. We don't want to hear when you were born and this stuff. Okay. Which department is doing this work?
Actually, the work is under disaster management.
Disaster management.
Yes, and through them, the PWD is doing the work.
So basically, you ask him whether the work is affecting his land, whether his land has been encroached or not. Can you ask?
Yes.
No. You tell me. What does he say?
Yes, Your Lordship, as per his instruction, that on 11 April 2026, a site inspection was conducted along with the petitioner.
Okay, along with the petition.
Yes.
And then?
And there, they found out that there is no demarcation regarding the LSC of the petitioner.
There is no demarcation
Yes,
of the LSC? What do
they
you
were
mean
saying
there?
like that because it is not registered under the GIS, so they cannot point out the actual boundary of the LSC. And that demarcation was under process, Your Lordship. And when the inspection was done, the problem was settled. And the petitioner...
Mr. Counsel, you have got a LSC, correct?
Yes, Lordship.
Have you made a representation to the Revenue Department?
No, Lordship, we did not.
You make a representation to the Revenue Department, ask them to have a verification done, and they will do it. They are the issuing authority.
So, Lordship, what happened was that, Lordship, if I just make a humble submission, is that we filed, since we were unaware of which department it was, so we filed it to the DC, Lordship. And in our prayer, Lordship, it can be seen here in, if I may take your Lordship to annexure number 5 and page number 32, Lordship. Here, Lordship, we have requested the Honorable, the DC, Lordship, for conducting an immediate, and if I may go through this, Lordship. Conduct an immediate inquiry to ascertain which department or authority has undertaken the excavation work on my client's land. Direct immediate suspension of any further construction or related activity within the land covered by LSC number 3341 of 1985 until the matter is lawfully examined. Conduct a joint inspection and proper demarcation of the said land in the presence of my client. Address and record the extent and damage caused due to excavation and dumping of soil. Initiate appropriate proceedings either for restoration of the land to its original condition or if the land is required for public purpose, commence acquisition strictly in accordance with 2013 Act and ensure payment for fair compensation, Lordship. So, Lordship, like we have mentioned here, Lordship.
Mr. Counsel, you are demanding everything under the sun. You see, you have got to be very clear first. You have to only find out, first of all, whether your land has been encroached. That's all. Then the next things will follow. You have to first find out the fact, whether if the land has been encroached, then only the other things will come. So, one thing is that you have not asked the Revenue Department also.
Certainly, Lordship, we did not do that. I understand that.
The
Lordship.
Revenue Department is the one who issued you
Lordship.
this land. Please listen.
Okay, Lordship. My apologies, Lordship.
Please keep quiet sometimes. It's not a one-way traffic. Anyway, right. Heard, Mr. Samuel, learned counsel for the petitioner, who submits that the state respondents have started an unauthorized excavation work on the land of the petitioner, which is covered by LSC number 3341 of 1985, located at Falkland, Aizawl. He submits, the petitioner's counsel submits, next para, that the excavation work on the land of the petitioner was undertaken without any notice or consent, without any notice being given to the petitioner or consent taken from the petitioner. He also submits that the petitioner submitted a representation dated 25/2/26 to the Deputy Commissioner, Aizawl, with a prayer to cause an inquiry to ascertain the department or authority which has undertaken excavation work on the petitioner's land. And if it was found that the land of the petitioner had been affected, the land of the petitioner should be acquired as per the acquisition law applicable in the state. On a query raised to the petitioner's counsel as to which department had undertaken the excavation work on his land, on the petitioner's land, the counsel for the petitioner submits that he does not know the said department. Full stop. Next para. Ms. Vanna Isiami, the learned counsel for the state respondent, is present along with, what is he? What is his designation?
I am junior engineer, sir.
Along with junior engineer of the
PWD.
Of the PWD.
Yes.
Who is undertaking the excavation work?
Yes, yes.
Excavation work for building a retaining wall. Correct? Yes. Retaining wall. Full stop. They submit that the land of the petitioner has not been affected by the land of the petitioner has not been affected by the work undertaken by the which department? Disaster and Management Department. Huh? Which department?
The work is undertaken by the PWD department.
Oh, is undertaken by the PWD department.
Yes.
Under the PWD department. Full stop. Next para. The above contention of the respondents clearly show that there is a disputed question of fact, which, first stop, before that you also said. The junior engineer had also said that a spot verification had been conducted on
11 April 2026.
11, don't say during the, say the government advocate, huh? And also submitted that a spot verification had been undertaken on 11/4/26, wherein it was found that the excavation work done by the respondents did not encroach upon the land of the petitioner. Full stop. In view of the above disputed question of fact, full stop. In view of the above, this court is of the view that no relief can be granted to the petitioner. However, if the petitioner is aggrieved, is of the view that some more is of the view that the statements, the submissions of the counsel for the respondent and the JEPWD is wrong, he may approach the civil court, which is grievance. The writ petitions are accordingly dismissed.
Deeply obliged.
Much obliged.
Unlisted item 15.
May I please? This is a statutory appeal, my lord, against an order for a conviction. My lord, the conviction has been granted for, my lord, 2 years, under 3 years, my lord. My lord, I am requesting for a suspension, my lord. I have a statutory right, my lord. My lord, may just have, for a minute, I have been convicted only under section 1, primarily charges for 120B, read with 420 and 471. 468 conviction is not there.
What is the under conviction under?
120B, read with 420. 120B, read with 471. So, the conviction is for conspiracy, my lord. My lord, there are two set of people. The government servants, my lord, who has seen all the document have been acquitted. The people who have purchased goods, my lord, have been acquitted. So, out of 17, my lord, 4 have been convicted. We are one of them, my lord. For 2-year imprisonment, my lord, probation of offender not even taken into consideration, though we argued that point, my lord, because you have to record a specific reason while not granting the benefit of probation offender. My lord, I was thrown out on the bail during that period of time, appeared on each and every date, my lord. My lord, I was on bail, my lord, there was a charge sheet without arrest, appeared on each and every date, participated in trial, appeared on the date of the order, my lord, by virtue of the court summon, and was taken into custody, my lord. My lord, just two things, my lord. If, my lord, can I just show few documents, my lord, in the appeal, just two. My lord, this is, if my lord may just have, page 149.
Which one? This one?
Yes, this is appeal. Sorry, my lord. The order runs into 350 pages. But, my lord, two things, my lord.
Which one? Page?
149. My lord, if I just take 60 seconds just to explain the case, my lord. My lord, there was a proprietorship concern, Carbon, my lord. Proprietorship is owned by a lady called Miss Margaret, my lord, who was accused number 2, who has been acquitted. I am the power of attorney who was doing this business for Carbon, my lord. My lord, there was a scheme floated by the government called NEIPP. If my lord may just have page number 149. There is a policy, my lord, which was floated by the government under the name of...
Just a minute.
149.
149 is part of the judgment.
No, my lord. It is... Yes, my lord, it's part of the judgment only, my lord. I am reading the part of the judgment. No, my lord, it's part of the charge sheet. It's an annexure, my lord. The annexure 2, my lord. But the judgments are in Roman numbers. The numbers are in annexure 149.
Yes.
Yes, my lord. My lord, may just clause 5. There is a policy mentioned, my lord, industrial policy and promotion in the state of northeastern region in a nutshell. My lord, 5.1. My lord, there is a policy called NEIPP in 2007. Because state of Mizoram, my lord, did not had coal mining, my lord, this policy came into play, my lord, by virtue of which the government decided that we will give subsidy to the people who will make a unit for coal. One, for making the unit, there is a subsidy on the capital and plant and machinery. Second, my lord, if the raw coal is imported from outside the state of Mizoram, there will be a subsidy granted to them. And when it is exported outside the state, there will be a subsidy to that. So, my lord, the ambit is, my lord, the petitioner before this court is, my lord, today, the person who was running the unit along with A2 is, my lord, Miss Margaret is accused.
Running the unit where?
In Mizoram, my lord.
Where in Mizoram?
My lord, the place is called, my lord, near Aswal only, is called, just one second, I am not able to spell the name, my lord. It is in Aswal, my lord, the unit was, my lord, near Aswal.
Running what unit?
My lord, he made a factory, my lord, for production of coke, my lord, from the raw coal, my lord, the production of coke, my lord.
Where?
Lungwal, my lord, is the name of the place, my lord.
Luangmal?
Yes, my lord.
Luangmal is here.
Yes. So, my lord,
I've lived in Aizawl also, I've never seen it.
Yes. So, my lord, the factory, and not the prosecution establishes the fact, yes, there is a factory, yes, there is raw coal which has been imported, because when the raw coal is imported, my lord, the taxes are paid to the government in form of GST, service tax, everything, my lord. The raw coal is imported by a coke supplier, my lord, outside Mizoram, my lord. Raw coal is then furnished, processed here, and coke was supplied, my lord, to seven purchasers outside. Purchasers were also made accused, who have been acquitted. The government servant, my lord, who has done a spot verification of my factory, have seen the production of coke, has verified each and every document in terms of the policy, have been acquitted. I am, my lord, being charged under 120B. My lord, may just have, there are 5 checks and balances, my lord. My lord, may have 5.2 at page 150. The policy, my lord. 5.2.
Yes.
My lord, for claiming benefit under the scheme, an eligible industrial unit has to be initially pre-registered itself as per the procedure laid down by the concerned state government. A unit submit its claim to DIC within a statutory time period as provided under the guidelines of the scheme, and thereafter such claims are scrutinized by DIC Center and Directorate Industries concerned. State government have constituted state level committee for consideration of such claim. Such claims are placed by the Director of Industry before SLC. The scheme envisaged timely holding of SLC meeting to avoid accumulation of claim as per the prescribed checklist. Based on recommendation of SLC, claims under CCIS will be pre-scrutinized, subsequent funds will be released by the nodal officer. Then, my lord, may just have page number 153. My lord, each of this department will physically verify importation of raw coal, unit, every document, my lord. My lord, may have 511 at page 153. My lord, after the highlighted portion, last 5 lines, my lord. Government UT administration concerned shall draw up procedure arrangement for scrutinizing the claim for subsidy under the scheme. State government administration shall carry out periodical checks and ensure that the raw material and the finished good in respect of which subsidy under the scheme have been given were actually used, produced for the purpose of system of scrutinizing of consumption of raw material and the output of finish, and cross verification with the power concerned payment of VAT, excise duty. The claim document submitted by the eligible industry shall be scrutinized by district industries, shall also be physically verification of the industrial unit to ensure the physical existence as well as genuineness of the claim before forwarding for recommendation of district industries. Directorate of Industry shall verify the claim document and recommend the district industry center prior to placing the same before the SLC. Then, my lord, this every department, my lord, have checked all my document. Physical verifications were done of the raw material, my lord. All taxes were paid. All documents which are there, my lord, were found in order. And, my lord, they have been acquitted. My lord, I have two submissions, my lord. The prosecution, sorry, three paragraphs in the petition itself, in the impugn order itself,
So your case is all the owners have been acquitted.
My lord, owner of MCP acquitted.
Owner of MCP.
Yes. Proprietor, because MCP is a proprietorship concern. She has been acquitted. The government servant who have checked all the document with regard to the raw material importation, because my lord, subsidy can only be granted if they do a spot check verification and verify every document. They have, my lord, checked all my document, they have done spot verification, they have seen production and verified that production by way of verification report. They have been acquitted. Raw coal, my lord, was thereafter processed and sent to the purchasers, my lord, outside Mizoram. They were also accused. They have also been acquitted.
Who? The purchasers?
Purchasers of the coal, my lord.
Purchasers of the coal?
Of the finished product, my lord.
What is the finished product?
My lord, lime coke, my lord.
Huh?
Lime coke, my lord.
Live coke?
Lime coke, LAMC, my lord.
Lime coke?
Yes.
What is it used for?
My lord, it steel industry, cement industry, my lord.
Cement industry?
Steel and cement industries. And my lord, they have...
But where is the steel and cement industry
my lord,
here?
they have sent the finished products to Bhutan and other places.
How? How do they send it?
My lord, they have placed document on record. Form Cs were also placed on record. The bank account statements were also verified that money has come into MCP by these purchasers. Purchasers have also given their bank account, Form C, tax returns showing that we have sold it to people outside India as well as within that state. All of the purchasers have also been acquitted. So, my lord, when the people who have checked my factory and has verified my document has been acquitted, people who have purchased the coal, my lord, have been acquitted, there is no point, my lord, could have not been conviction against me, my lord. And, my lord, I have the total number of subsidy which has been granted to me in two heads, CTS, which is a transport subsidy, and CIS, which is basically for investment subsidy, was approximately 3.5 crores. On Total. On the purchase, on the import of raw coal, production and supply, I have paid 4.5 crores of taxation of CGST, sales tax, verified by every department, all were in play. So if there was no coal ever imported, there was no need for me to pay the subsidy of pay the taxes of GST, VAT to these departments. There was no need for me to, and all of this is verified. And, my lord, on a legal question, my lord, two judgment, my lord, of the Supreme Court and direct judgment, if there is no 468, because the case was that MCP has made forged document, given it to the government department, because of which subsidy was granted. It was not a case of an isolation of 420. 468 is forged document were given for the purpose of cheating, because of which subsidy was granted. When 468 is not there against anyone, there cannot be 420, because 420 in this case is a parasiting section to 468. When there is no 468, there will not be 471. More important, my lord, there was a charge frame of 109, because the integral part of 120B is abatement. The court has acquitted everyone for abatement. So without there is a charge of an abatement, how 120 will also be survived? And why not parity to be granted? I will read, my lord, few paragraphs of the impugn order. My lord will find, while acquitting these government servants, my lord, the court says they have not committed any illegality. All documents were found to be genuine. The IO comes in, my star witness is IO. IO comes, says there is no loss to the government, because the money paid to the government is more than the subsidy which is claimed. These are witnesses, my lord. And, my lord, one more important factor. My lord, my lord, with utmost respect and humility, my lord, I say, my lord, there is a fallacy in the investigation and the procedure adopted. No author was, my lord, brought to the court to testify on the content of the document. Only people. On the content. My lord, there were registers which were seized. Registers which were seized, my lord. Multiple registers. Everything hinges on those registers. To show that you are saying that 2,000 trucks have come, and you have placed, my lord, we have placed every document of each truck driver, the driving license, truck details. IO says I did not bother to even go and investigate the truck driver. There is no investigation, he admits. We have given bank account statements from the people whom we have purchased coal. He says I did not bother to go there and ask to those coal whether you have supplied or not. Purchaser, we have given bank statement and we said there are 4 more purchasers. You have made only 3 people accused. Why selectively not other people? He said I did not go there. The trucks come from multiple gates. He said I did not go and check those gates. There are multiple registers at the same gate. He said I did not bother to check, get those. Authors of these registers were not even brought to the court. They tried to prove these registered by the person who has seized. Seizure, these people deny the seizure, and the people who have come to depose for these registers says we joined job. The duration is 2011 to 14. These people joined later. So seizure people try to come. None of the electronic document is substantiated with a 65B evidence affidavit. Nothing. 249 was given go by of CRPC. Sorry, 294. There is a mandatory procedure for an admission denial. Not done. No document was put to any of the accused or anyone. The charge against everyone was framed in same cut copy format against everyone. Summoning order was a cut copy paste 1-line order against everyone. No independent charge was made even for against anyone. I have placed all the charge document. I have not placed detailed chart while arguing this matter. None of them were considered. For every stage to show, and it is the prosecution witness only who have demolished the case of the prosecution. The court, selectively in the impugn order quotes the cross-examination of the witness. If you see the same cross-examination of the full cross-examination, in 2 lines thereafter he denies that thing. So I am only saying, these are points, which required. We are under 2 years, my conviction is for 2 years, under 3 years. 381, says I should be granted a benefit of a suspension. My grandfather, has died on Sunday. I have placed the death certificate, on record. Is my maternal grandfather,
Maternal grandfather?
My Nana, has died, The last ceremonies are there, I am, a law-abiding
citizen. Died
where? In Calcutta. Not a single past criminal antecedent against me, Absolute. It's the first probation offender says, he could have, the trial court would have suspended it there and then, The trial court would have not even granted any kind of order.
Who is the appellant here?
Ravi Bulgulia, there are 2 people, 2 appeals. One is Ravi and one is Sandeep. Sandeep, is not part of MCP at all. He is the only charge against him is, in the whole allegation is, that for the purpose of transportation, the certain local people outside Meghalaya were engaged. They came, they became approver. They said, we have not done any transportation. Mr. Sandeep has taken our bank account and we have given him signed checks, signed everything. And he has given me money in lieu of signing those checks. And he has done all the transaction. No problem. Giving signed checks to somebody is not an offense. Section 20 of the Negotiable Instrument Act says the presumption is that you yourself has given.
But the checks were used for what?
To make payments to the coal supplier. There is bank entry. The IO says, I have checked all bank entries. There is no reversal from there. No purchase, no coal supplier ever returned money back. So there is no money which is routed. He says every bank transaction is genuine in nature. These approver, the whole case hinge on, so there are 2 set of documents. One, the document which are my e-way bill, transport bill, tax document, which are today by the prosecution says all of them are authentic. All of them are given to the government servant. They have done verification. Everything is correct. My ground for conviction is 8 approver statement. Who were the coal transporter? After transporting, they allege that we have not done the transportation. 1. And 1 coal handling agent who procured from the original person. He said, I have not done anything. But each claim has to be accompanied with all these documents. E-way bill, tax certificates, verification report by every government servant. And an affidavit by these people. They say affidavit, we have not signed it. Affidavit goes to the FSL, the signature is found mismatch. But the investigating agency did not even bother to take the signature of any of the accused to match it from there. Therefore, the court acquits everyone under 468 that there is no forgery made out. The prosecution is not able to point out who has done this. Whether they themselves has done it or not, we do not know. So, some documents are found mismatch. Of the same people, other documents are perfect. So the chain, my lord, benefit of doubt is one of the main strong argument, my lord, would have been given. Today the chain of the prosecution is not established. My lord, the fallacy in the procedural trial is, the basic principle is, when a person says my document is forged, in the chief you have to put that document to him to say identify various signatures. No document in the chief was put to any of the witness. Nothing, no document is shown. IO exhibits all the document. In the cross-examination in chief, no document is opened, shown to any of the person who today disputes it. IO marking document will make no difference. He is not the author of the document. The people have to come and say, this is not my signature on this document. If there are 10,000 documents, the court has to come to a finding which document is forged, who has forged it, who has used it for what purpose. Absolutely nothing on this. And that is why, my lord, the reason for acquittal. And that is why reason for acquittal under 109. And other people, my lord, may just have few, I have reproduced in my appeal, my lord, the important questions, my lord. If can I just show 4 questions, my lord? If my lord may just have. My lord, at page number 28 of my appeal, the appeal petition. There were 6 pages in the whole transaction. They said that the MCP is a sham company itself. And they made an absolute case because they said total subsidy which has been granted should have not been granted because there is no raw material ever came, no production happened. But while acquitting everyone, they said yes, everything was right. My lord, may just have page 28. This is the cross-examination of PW7. There were 2 IO, initial inquiry IO, my lord. Just few questions, my lord, may just mark. Page 28.
Yes.
28 of my appeal. My lord, may see serial number 4. This is a cross-examination of PW47. It is a fact that during my inquiry, I did not discover any non-compliance and illegality committed by the accused person. My lord, may then turn to page number 34. Page number 34. Not one, my lord, I will show 100 of these questions, my lord. Page number 34. My lord has it.
Yes.
My lord, 93 and 94. IO says, I have personally seen the factory and allied infrastructure which was constructed by MCP. I also took the photograph of the factory and other infrastructure. I have seen those photographs. I have sent these photographs with my charge sheet. Photographs clearly prove MCP unit was actually in existence. As far as I know, there is no irregularity in respect of CCIS claim. Lord, this is my investment claim made by MCP as per exhibit so and so. During my investigation as regard to CCIS, I did not seize any other document except so and so. So he himself says there is no problem. My lord, may just have.
He's the IO.
Yes, he is the IO. My lord, may just have few more. Page 57.
Yes.
Page 57.
Yes.
Question number 54. 57, italic 54.
Yes.
During my investigation, I did not find there was any loss to the state exchequer.
No, no, I did not find whether.
Whether there was any loss to the exchequer, because not few questions above he reproduced that how much service tax in every head for raw material, importation, production and export have been paid. It is 4.2 crores, not page 56, 52, 50 and 52. It says 50. It is a fact that the sum of 48 lakh collected as MVAT on the same transaction on which internal investigation was conducted and is also included in the tax paid by MCP, 4.2 crores. This is a tax paid, my lord. My lord may just have page 58.
Okay, I think let us hear. Yes.
My lord, on the merits, we'll have to examine the whole contents, my lord, because we have just received this morning.
So basically, the thing is that the owner has been acquitted.
Yes.
Owner has been acquitted.
Government servants who have checked every document.
Now, these persons, whether they can be singled out.
Like I've said, my lord, I'll have to examine the whole
So another thing is
evidences.
the punishment is 2 years.
2 years.
And they were on bail earlier.
Yes.
So
For suspension, my lord, the learned
suspension
trial
of sentence only. That's all.
Yes. The learned trial court has the jurisdiction to grant him suspension. However, this was rejected on several grounds.
The bail.
The
Bail.
suspension.
The suspension. My lord, under 389(3) says, till the time I file an appeal, I can tell the trial court only. Trial court says, my lord, you
But-
may flee.
So what is the ground? Let
Yes,
us-
my lord, may just see that. It is with my suspension application. But these are not on the order is there, my lord. Annexure A2 with my suspension application.
Page.
My lord, at page 43, my lord, 41.
The
With my
last para.
suspension. It's a common ground to everyone. After hearing this both sides submission.
41?
41, my lord, with my suspension application. There's a suspension application separately numbered. Which has the death certificate also. There's an IM, lord.
Yes.
My lord, page 41 of that is the order. Though, my lord, I should have been granted then only. Last paragraph. After hearing both sides on careful perusal of the application, the court find that all applications are not resident of Mizoram and they may be a chance of absconding. Further to the trial, in the instance it is complicated and difficult to process the case, and because it was pending for very long time. Further, the misappropriated amount is in the case amount is more than 3 crores, which affect public exchequer. For all this reason, the court feels public at large that they should be in jail for some time. That is the ground. No special. The court says you have to record a special circumstance to refuse the bail.
Where does it say that?
But the 389(3) says, the statute itself says. But I was on bail. I was appearing throughout. If I did not want.
Give me CRPC.
Yes, ma'am.
IPC now.
My lord's power to suspend is unfettered by this order because this was only till the time I file appeal. And my lord, I can show my lord orders of this very court suspending the sentence, my lord, in prevention of corruption, all matters every day. My lord, may just see 389(3) provided order of, I'll read the 3. The conviction where the convicted person satisfies the court by which he is convicted that he intend to may please. my lord, the after 3, my lord, subclause 3, Roman 2, after that, ordered that the convicted person be released unless there are special reason of refusing bail. There was none, my lord. I did not abscond during that time. I was appearing. I did not tamper. There is no reason. These reasons existed during the course of the trial. There is no special reason. And my lord may just see, my lord, the court is not even suspending but staying the sentence order, my lord. This very court, my lord. Multiple orders, my lord. This is on suspension. My lord, these are the orders, few across the country and of this type of exacting offences, more harsher, my lord. Not only this, my lord. My lord may just have few of them, my lord. Page number 63 of this court, my lord. Same as arising of the same trial court. My lord, the trial court is also suspended, my lord. In 21 cases I did the search, even in prevention of corruption. My lord, page number 63 at 64, my lord may see the section are same, my lord. At 64, 409, 419, 420, 468, 471, though I don't, and 13, prevention of corruption. It says that it is less than 3 years, my lord. The page 65, the judgment and the conviction order both, my lord, suspended, my lord. My lord, the case runs into 60,000 pages, my lord. The documents are 60,000 pages plus, which and 117 witnesses came, my lord. I have placed, my lord. My lord may then have page 73 also, my lord. This judgment of this court only, my lord. 69. There are multiple judgments of the Gauhati High Court and Lord, this bench also. 69. Same sections, my lord. Prevention of corruption. The 389(1), my lord, gives the power to this court.
So you have filed this under what, 430 or under 389? Which one?
BNSS. Because
BNSS,
yes,
430.
Because, my lord, the saving clause says, my lord, unless all with the old act only the pending appeals and petitions are saved. So I have to use the new one. Common order for the other one also.
Yes, anything, Ms. Linda?
No, my lord. Since the learned trial court has given some reasons, my lord.
If you want, we can take it up day after tomorrow. We'll give you some time. We'll give you some time to think about it. Because it's come today.
Yes.
So we will give you some time. We can take it up on
Thursday
or Friday also. Whenever.
Lord, can I only make one request, Lord? If they can be released on an interim, Lord, they will be present before this court, Lord. Lord,
Let her. It's come for the first time. And this was not, if it was some time had been given to her, I could understand. But you will take it up day after tomorrow, Thursday.
All right,
Thursday, and then so you see, because you see, prima facie, everyone, they are who are they? They are the ones who are operating it.
Lord, only the petitioner Ravi Gulgulia is the one who is operating this. This person was not operating the MCP. The other two persons are manager. Two are manager who are inside. One manager has been scot free. So I don't understand the parity, and we can...
One manager is free.
One manager is free. The chartered accountant is free. I will read the passage exactly, and my lord may see the prosecution
Who is the manager who is free? What is his name?
A5, my lord, Kajal Kanti Devi.
A5. And manager.
My lord, the allegations are so serious.
And what about the chartered accountant? He is A?
He is acquitted, my lord.
Accused number?
My lord, I'll just tell the accused number. His name is... Just one second. Sorry. A11, Santosh Jain. He gave the certificate. Acquitted. The government servant, my lord, may see the allegation. Can I just show one page of the allegation? That whatever you checked was not correct. Your reports are forged of the spot verification of the unit. Your report for verification on each document was not correct. And they are acquitted. The court believed, no, everything was right. They did their duty perfectly. They did the spot verification. To convict me, there are only two reasons. He says, it is agreed by the purchaser that you have supplied them the goods, but I feel that you may have bought it from somewhere else. This is not the case of the prosecution. He presumed himself. He said, you must have purchased all this coal from some undisclosed location and sent it to them. But they have given bills, bank account statement to show that they paid me. Form C, my lord, which are government document. They have paid taxes on it. We have paid taxes on it while supplying it. Transporter details to every truck number, to every truck driver was given. And prosecution admits that part. Lord, can I make only one request, Lord? Can it be tomorrow, Lord, if Lord is not, otherwise Lord can release?
Not tomorrow, division bench paper. Lot of matters.
Lord, any point of time. Then Lord, can I request?
Your junior can be there. You have made
Lord,
your
I have lived this case from last 2 months myself, Lord. There are too many facts, Lord. That's it. Lord, can I request then, Lord, an interim may be released, Lord?
No. Day after tomorrow.
Then, Lord, can I request for Friday? Lord, I am in a part in Calcutta.
No problem. You are lucky. She's not asking for filing a written objection.
Lord, I will then able to place, Lord, other two also, Lord, by Friday. I will file.
I don't know. You place whatever. Basically, this, because once we pass an order, that will basically cover everyone.
That's what I'm saying. I'll not have those.
I don't know. I leave it up to you. That's not up to me. It's up to you. But, madam, you have got to think.
Yes, Your Lordship.
You see, because you see, there's nothing here which should show that they are going to abscond. It is below 3 years. And everyone else has been acquitted. Right.
I have participated in the trial, Lord, from last 6 years. It's not.
Well, that happened. They are lucky it at least ended within 6 years. So many cases where 10 years they are under trials. Yes. Heard, Mr.
Jatin Sehgal.
Learned counsel for the appellant. There are 2 appeals or 1 appeal?
2 appeals.
2.
Learned counsel for the appellant. This is an appeal against the impugned judgment. Where is that impugned judgment? Impugned judgment and order dated 23/7/2026 passed by the learned special judge, Prevention of Corruption Act, Mysora, in SR bracket PCA number 4 of 2019, by which the appellant has been convicted under section
120 read with 420.
120B.
120B read with 420.
B/420 IPC and 120 120B/471 IPC.
Lord, can I just make, it is red, it is not 420 red with 120. This will change, my lord, the impact also, my lord. Had it been 420 red with 120, then I would have been probably charged for the primary offence of 420. Since it is 120 red with 420, the connotation changes, my lord, and I will submit, my lord, on that. That is my submission. One of my submission is that I am only charged for now conspiracy. These are charges for conspiracy. 120B red with 420, 120B red with 471.
So we put slash, it's okay.
But it says red with and comma, my lord. It will change. I leave it to the court.
How does it matter? You make that submission the time final.
I will.
120B/420 and 120B/471. Admit the appeal, call for the TCR, issue notice, Miss Linda Alfambo, AG, additional AG, PP accepts notice on behalf of the state, list the matter after 4 weeks. List the matter, give a date, give a date in September. Then in the IA, you're right, heard so also, this is an application under section 430 bracket 2,
Yes,
BNSS, for suspending the sentence to be undergone by the applicant appellant pursuant to the impugned judgment and order dated 23/7/26 passed by the learned Special Court PC Act Mizoram Aizol in SR PCA number 4 of 2019. The case of the applicant is basically to the effect that while the owner/proprietor of the Mizo Carbon, what is that name? Mizo
Carbon Private Limited.
Mizo
Carbon Product.
Mizo Carbon Product.
It's a proprietorship.
And the government servants who had apparently checked and verified all documents, the factory and the production process had been acquitted. Only the applicants who were working in the said industrial unit have been convicted. Further, the purchasers of the finished product have also all been acquitted. As such, there could not have been any finding made by the learned trial court with regard to there being any conspiracy or violating or of having committed the offence under section 420/471 in the absence of any finding that an offence under section 468 IPC had been committed. The counsel for the applicant also submits that no one has been convicted on the charge of abetment in the case. The documents relied upon by the prosecution have also not been proved by the author of the said documents, and there is no certificate under section 65B in respect of electronic evidence relied upon by the prosecution. chartered accountant, bracket, accused dash 11, huh? A dash 11. And one of the managers, bracket A dash 5, have also been acquitted. He also submits that next para, huh? He also submits that the application made by the applicant before the learned trial court under section 389(3) CRPC had been rejected without the learned trial court providing any special reasons for rejecting the same. Full stop. He accordingly submits that the sentence to be undergone by the applicant should be suspended. Mrs. Linda L. Fumbo, next para, additional PP, submits that she may be given 2 days' time to go through the materials which have been provided to her today. And to list the matter after 2 days. List this matter on Friday. When do you want? Friday or? You want it Thursday or Friday?
Friday. I'll be physically here. I don't want to do this online.
You don't want to do it online?
Yes.
Friday.
Can I ask for one more indulgence more? Can it be at 2 o'clock on that?
No. 2 o'clock is
because
Friday is the problem.
It's difficult to reach from Calcutta to that's all.
You do it on Thursday. What is there? You've got some matter somewhere else.
But I'm arguing at 3 o'clock before Calcutta High Court in that TMC matter. Somebody who got arrested in the ED. That's part heard going on.
Yes, who is there from Gauhati? What is this?
No, my lord, I am not in this matter. In fact, my lord, I also have a small prayer. My junior appeared in item number 13 as I was in another court, my lord. Your lordship has fixed it day after tomorrow. My only predicament is this, my lord. On Friday, I have a charge hearing in Karimganj court, and therefore I am physically coming to Aizol on Monday, my lord.
No, you come on Thursday and you can go. You can take the night train at 7 o'clock. You will reach Karimganj at around 10 o'clock, 11 o'clock you will reach Karimganj. So,
my lord,
so you can have a good night's sleep and the next day you can appear in the court.
My lord,
we'll arrange a ticket for you also.
My lord, I'm grateful. My only issue is this, my lord, because there are certain judgments which I'll wish to rely. I'll be physical.
Is it that case under 227?
Which one, my lord? 227?
Is it that case under Article 227?
Article 227. No,
it's
my
a
lord.
Revision petition. No. What is it?
No. My lord, it's a simple bail application, my lord. My only thing is that
No.
Sorry.
No, my lord, because Thursday I'll not be able.
If you are sorry, you cannot make such submission.
Lord, can it be,
I thought you were in this case. That's
Lord, can it be Thursday only, my lord? I'll do VC, my lord, because Friday also I'll not reach.
Thursday
VC.
Thursday at 2 o'clock, huh?
Lord, can it be in the morning? I have a 3 o'clock matter. Lord, can it be
Okay.
in the morning?
I will do in the morning.
In the morning, any fixed time, Lord, can indicate, Lord.
We'll see. You make a mention. We'll see.
I'm so grateful, Lord. Extremely grateful.
My lord, item 13, can there be any possibilities, my lord? I'm deeply, my lord.
Sorry. No, not at all.
I will not be able to argue that.
You can come. You can do it virtually.
I'll take the liberty of mentioning the other also, but what will be the fate for this? We'll see for that also.
You see, this will decide everything.
Wait, that's what I'm saying. Let them also be placed, but I'll file that tomorrow.
This is this same order, huh? Same order.
Lord, I'll
in
file
this case also same order. Both the case, ditto.
Lord,
both same order.
I'll file that also. Lord, can also be listed on Thursday.
It can be. You file, it'll all come together.
Yes. It's the same thing, we have the
Same
common
thing,
thing. I'm so grateful.
So we have still got matters. Oh, okay.
Part 2 hearing, item number 4.
Bishop, this matter,
Ah.
before your lordship takes it up, there's one small, the appellant in this case has another case pending, RSA 1 of 2014, V. Zo Dilpuya versus Ral Kapzawi. And your lordship, that was your case. It was filed by you.
Oh, filed by me?
Yes, sir.
Oh, so I cannot take up this case?
Yeah, to prevent any apprehension
Oh,
of
sure.
bias.
Achha, achha.
Because in that
so
case,
I was for Ral Kabzawi?
No, you were for V. Zo Dilpuya,
Ah.
and Ral Kapzawi is the respondent there.
Okay.
Here, Ral Kapzawi is the appellant.
No, is there any connection in the cases?
The connection is your lordship. I mean, you filed a case against her.
I don't, this is completely, you see, whenever I do a case, I never look at the names of the parties. I never. That is why, if you remember, in one case I had passed a judgment against a relative. And that relative then filed a review. I still rejected the review because I said nothing to. Then I went by thing. The thing is that I don't look at names. So but then if you have got some problem, I've got no problem. We can adjourn.
To be on the safe side, right?
Okay, no problem. What?
It's up to you. Next week, this week.
Right. It's possible that that lady, supposing I pass an order against her, she can say this fellow was
past grudges. She has two husbands.
Okay.
The earlier case was filed by you against
her first husband.
First husband's stepson.
Okay.
You had appeared on behalf of her stepson.
Okay.
So basically, she's fighting for two properties from two different husbands, madam.
Oh, okay.
Airship
okay.
cases.
Oh, right.
Very lucky.
He's very smart. It's like this. It's like this case in the this lady who I think married around 7-8 times, and from each husband she was claiming maintenance. but then the court caught on and dismissed her case, last case. So she used to get married for 3-4 months and then claim maintenance. Anyway,
After a week.
when you
After a week.
list on the press of parties, list the matter after a week.
Obliged.
Arey, not before Justice Malli, not before Justice Nelson, not before me also, then public. Finish? Okay.
My lords, item 6 is still there, fixed for today. It's a simple matter, my lords.
Okay, okay. Give me item 6. Yes.
May I please, Your Lordship? This is an appeal against the impugn order passed by the Honorable Civil Judge Senior Division 3, Aizawl District, in the airship application number 1029 of 2025. If I may take you to page number 1, I have attached the order. If I may, my lord, if page 1A, that the operative part is
Yes, so the question is whether an appeal can be filed against the judgment.
Yes, my lords. I have raised that maintainability objection, my lords, because here, my lords, the appellant has invoked Order 41, read with Section 96 of the CPC, which basically deals with an appeal against decree. But this which the present appellant is challenging cannot be deemed to be a decree as per the CPC. It's an order. It's an order passed in an application, my lord. So,
But I think there is a decision that appeal can be filed against the judgment also.
This is only an order passed in an application, my lord.
Oh, in an application.
Yes, yes.
Oh, it's not a final
Not
judgment.
a final suit or anything. It's only an airship application.
Okay.
My lord, in the definition part in section 2 of CPC, here it clearly mentioned that if...
No, let me see the order first of all.
Okay.
The impugn order.
If I may take you to page number 1.
Page 1.
Yes, my lord.
Page 1. Okay.
See numbers.
This is airship application.
After submitting the written objection by the respondents, right, it was straightly rejected by the Honorable Court. So we are
The
not
instant
given,
application is rejected?
yes, my lord. No reason was given here in the order itself.
This is the final order. This is the final order. This is the final order. I thought you were talking about interlocutory order or something like that. This is the final order. This is the final decision. Some finding has to be made by the court as to why it has rejected this.
My lord.
It cannot. This is the final order. So we'll send it back to the court to decide.
Yes.
Okay.
Much obliged, my lord.
Heard, Mr.
Zaudin Puyat Hamte.
Zaudin Puyat. So. Also heard Mr.
Sitlan Thiang Lim. I'm appearing as a legal aid
Tan
counsel.
Thiang Lim, learned legal aid counsel for the respondent. The appellant has filed this appeal against the impugned order dated 7/11/2025 passed by the Court of the Learned Civil Judge (Senior Division Roman 3, Isol in Airship Certificate Application Number 1029/2025. The next paragraph. The Learned Counsel for the appellant submits that the Learned Trial Court had rejected the airship certificate application made by the appellant
Yes.
without giving any reason for the same.
Yes, my lord.
And after the respondent had filed the her written objection to the grant of airship certificate to the appellant. Next paragraph. The impugned order dated 7/11/2025 passed in airship certificate application number 1029 of 2025 is reproduced herein below as follows. This from here. I'll just put this. There's para 1, 2, 3 only. A perusal of the above impugned order shows that a final order has been passed in relation to the airship certificate application number 1029/2025 by the Learned Trial Court without giving any reasons for the same. It is the bounden duty of the trial court to pass an order with reasons. The same not being done, the impugned order is unsustainable in law. The same is accordingly set aside. The case is remanded back to the Learned Trial Court to take a fresh decision only after giving reasons for the same. That's all.
If I may, my lords, if notice may be issued to the respondent herein, because I'm only appearing as a legal aid counsel.
Okay. The learned trial court shall proceed with the airship certificate application number 1029 of 2025 only after issuing notice to the respondent therein. In appreciation of the assistance provided by the legal aid counsel, his fee shall be paid by the State Legal Service Authority.
My lord.
State Legal Service Authority. Okay.
Obliged, my lord.
Much obliged, my lord.
So, actually, some reasons have to be given.
Yes,
It
my
cannot
lord.
be. There is no reason at all. Oh, that gulgule thing. Tamlu tuwa lekhan ngal tuwa. Hey, khoy mi ngal. I need to tell them. I've got this backache, no? After I sit too long, it's difficult to stand up.
Yes.